May I please, your lordship. My lord, I listing for a motion matter on Friday, my lord. It has been filed on 27 only. Obligement.
May I please, your lordship. I beg to mention for withdrawal, lordship. Tomorrow. Much obliged.
Lordship, I beg to mention for listing two cases, one for hearing, other for admission.
Hearing, no.
Lordship, can you
Other one,
please,
admission, okay.
hearing matter, Lordship,
Make
connect
an
the case
application for
already.
early hearing.
Lordship.
Make an application for early hearing.
Please, Lordship, I am preparing for listing a motion matter, Lordship. Lordship, this matter already listed last week before bench 5. The Honorable could direct to list, direct the registry to list.
When do you want?
Lordship,
When you want?
tomorrow, Lordship, if possible. Highly obliged.
Like to mention for listing of a writ on Friday, Lord.
Motion.
Admission matter, Lord.
Give it to the court now.
May it please your lordship. Lordship, this is with regard to item number 3 on today's list.
Item number 3.
I'm appearing on behalf of Mr. R.K. Agarwala. He has some personal difficulty, so with the consent of the other side, we are seeking 2 weeks' time.
Okay, you are Miss? You are Miss? Name?
J. Goswami.
J?
J. Goswami.
On the request of Mr. J. Goswami on behalf of Learned Counsel, on behalf of Mr. R.K. Agarwal, Learned Counsel for the petitioner. List the case when? When do you want? When do you want?
2 weeks' time.
List the case after 2 weeks. Is submitted that form. Take it from the Learned Counsel for the respondents to make the prayer. List the case accordingly after 2 weeks. On the date 2 weeks by the office.
May I please, your
Yes.
Item 8, your lordship. Lordship, I'm praying for adjournment of this case, Lordship. Senior counsel Madri is not well yet. Taking the
Okay.
contact.
8. Mr. P.K. Bora. You are for
Lordship.
respondent.
Respondent number 226.
226. You are Miss
M. Tiwari.
Mr. P.K. Bora, Learned Counsel for the petitioner, has made a prayer for adjournment. The ground that Dr. A. Sharaf, senior counsel, who is leading him in this case, has some personal difficulty. Also, Ms. So-and-so, Learned Counsel for the respondent number 226, has stated that the respondents have no objection to the prayer. So the rest sought for and agreed to with the Learned Counsel for the parties. When do you want?
Yeah, 3 weeks.
Please the case. But she is on
Moderate.
the interim order. It shall continue till the next.
Pleasure.
Obliged, Lordship.
Supplementary list.
Mention. May I please, your lordship? I beg to mention one criminal appeal jail to come up for orders. Admission, my lord.
This is not the bench.
Sorry, ma'am.
Supplementary list for motion. Item 12.
Please.
The page 110 is the impugn order. My contact has been
Page?
prepared. 110.
Pentameter. Yes.
110 annexure 8 my contact has been terminated.
Page?
madam. Yes, madam. But here, madam, my
Page?
110, madam. 110, madam. I have been annotated, my lord,
Termination.
restaurant course, my lord, at New Jalpaiguri.
1 minute, let me. What is ORH?
Means, my lord, officers rest house, madam.
Clause 17.8.
Yes, my lord. That is at page 84, madam.
Whether this The type of dispute is not subject matter of arbitration.
No, my lord.
Huh?
My answer is no, my lord, but this
No,
honorable
no,
has
is
the-
there any arbitration clause
Yes,
or
ma'am.
not?
page 85, my lord.
It falls under the dispute resolution process.
Now, my lord, it's a recent, my lord, this court has held that, my lord, if the, my lord, order is perverse, my lord, or arbitrary, my lord, then this honorable court has the resolution to terminate the.
Perverse, they
Yes, sir,
have,
that's why, my lord, I am showing.
they have invoked a clause.
Kindly see, my lord, 7.3, my lord, page 83, my lord, notice has to be given, my lord. Page 83, my lord.
Which clause?
Page 83, my lord, clause, my lord, 17.3, my lord. Before, my lord, kindly see, my lord, page 82, my lord, this is a.
Don't take me to
Hey,
suddenly this one, this one, this one. How can I read it so
Yes.
fast?
obviously, my lord. 17.3, my lord, termination.
Now, what is the agreement? What is the contender?
Yes, my lord. A tender is start from, my lord, page 19, my lord. Page 24 is the, my lord, main object, my lord. Objective of the tender.
What is the subject matter? Of India.
My lord, page 24, my lord.
Cooperative Single case. Food and service for set up and restaurant company. Set up an operation of coach restaurant,
Yes,
come
madam.
food and tea stall.
Yes, my lord.
Which station? Railway station?
My lord, New Jalpaiguri, my lord, is Katihar division, comes under the NF Railway, my lord.
Okay,
Madam.
then where is the award?
Yes, my lord. Page, my lord, 97, my lord. 97, my lord. This is the work order, my lord.
Yes.
Now, my lord, as per the work order, my lord, for the first
Mhm.
year, for the first year, I have paid the my installment. For the second year also, my lord, I have paid the installment, full installment. So what had happened, my lord, from the July 2024, my lord, in the New Jalpaiguri station, my lord, the railway my lord, started to my lord, construct the building, my lord. Thereby, my lord, the entry point, my lord, where it has to be reached to the restaurant has been my lord, closed, my lord. Now, my lord, hide, my lord,
What
100
what is the railway's duty in the agreement
yes, my lord.
that it has to give access to the restaurants? Anything?
No, my lord. No, my lord. But I have intimated, but there's a clause, my lord, if it entries happen, I should inform the railway authority, my lord.
Where is that?
6.5, my lord. Page 76, my lord. Bottom, my lord, 6.25, my lord. The licensee shall furnish all information on the record within 10 days by railway from time to time, failing with the railway reserve the right to impose suitable penalties on licensee during termination of agreement along with the other attendant liability. And my lord, clause 7, my lord. Page 77, my lord. 7.1 point B, my lord.
7 point.
1 point B, my lord. May I read, my lord?
It should be the obligation of the railway to provide access to the restaurant.
Yes, my lord.
Where is that clause?
That was not there, my lord. But it is in the, my lord, noted, my lord, at the entry and the exit point of the platform, my lord. That's why, my lord, I have given the, my lord, photograph also, my lord. Now, my lord, the page, my lord, 102, my lord.
Where railway's obligation is there. Right.
It's not reflected, my lord. Only, my lord, clause 7, article 7, my lord, provided, my lord. Page 70,
Page?
page 77, my lord. Yes, my lord, if I sought for any assistance, my lord, they have to pay me.
Then what happened?
Now, my lord, 102, my lord, kindly see, my lord. This is my information to the railway, my lord. I submitted through, my lord, email, my lord.
Yes, then what happened? Did they reply?
No, my lord.
Hmm?
No, my lord. I have annexed the photograph, my lord. 105 is the, my lord, at the initial, my lord, at the time of operation of restaurant, my lord. 105, my lord. You can see this is the entry point, my lord.
Hmm. Yes.
106, my lord, the internal part, my lord. Now, my lord, the 107, my lord.
This platform is in which side? Other side.
Yes, my lord. The entry point, my lord. The hands up, they have constructed, my lord,
Yes, yes, yes.
thing, my lord.
Yes, this has been demolished or what?
Yes, but the.
Front part is
entire-
demolished.
No, but the end.
Front part is demolished,
Yes, my-
107.
Yes, yes, my lord.
And what is 111?
111, my lord, I have been asked to remove the, my lord, the restaurant, my lord. But here, my lord, they have admitted, my lord, that there's a construction is going on, my lord. That's why, my lord, they wanted the land, my lord.
So I think that is, they have the right, I think. So far that is concerned, 109. If they need the land,
Yes, my lord. But they may explore another plot of land, my lord. Because I have invested, my lord, because. they have-
right,
Yes,
right.
my lord. They have only, my lord, provided.
That I have seen.
Yes, my lord.
You have invested,
Yes.
but if it is required in the broader public interest,
But I have no problem, my
right?
lord.
So far as that land is concerned, if they need, I think I have seen somewhere. Which part is, which
111.
clause is that?
Yes, my 111, my lord.
Huh? No, no, not 111, the clause in the agreement. If they need. It is in the work order document. The work order,
Lordship.
where is the work order?
97.
97, man.
90.
Railway
Seven.
will only provide the skeleton of the coach.
Huh.
No, no.
I have seen somewhere. Termination or, where is the termination clause?
Page 83, my lord.
Those are. Solutions. Now come to page 65, that is the performer agreement. And operation. Yes, Mr. Day. He has intimated.
They're intimated,
You
Lordship,
need-
I've- whether 17.3 has been complied, Lordship, I have to take the instructions, Lordship.
Because
Here's no reference is given in page number 110, Lordship.
17.3
Yes, whether 17.3 has been,
be due to non-payment, but he has intimated.
he has intimated, Lordship.
uh,
I have to,
Now,
that,
there are two issues. One issue is that suppose it is impossible to operate now
Lordship.
because of construction, that is larger public interest. You have
Lordship.
to- Private interest has to
obviously.
give way to larger public interest. If the railway station is being constructed, renovated, that has to give way. But so far as your information on 8/8/2024 is concerned, that access to restaurant is blocked, so my business is stopped. In that case, recovery should not be.
Lordship, that-
But at this stage, we cannot make it
Obviously,
Lordship.
the contract
Obviously, madam.
operational because of that the land is required, seeing the picture
No,
also.
my client also requested me provide me some suitable.
All right, for the, at this moment, no coercive action
Yes,
against
yes.
you,
Lordship.
right?
Lordship.
So far as recovery is concerned,
Lordship.
anything, no penalty as on date.
Lordship.
Everything should be kept in abeyance
Lordship.
because it appears that if you require a land, you require a land.
Lordship.
Then that is, you took the plea that non-payment,
Lordship.
right?
Lordship.
But he has intimated on 8/8, what is 17.8? Let us see 17.8.
This is my lot,
3.
Page
84, madam.
84.
17.3 is my lot, 83, madam.
17.3. You saw, you mentioned about material breach, right? Material breach, but he has intimated. So if that is so, then the one thing I have just seen, that is, if you want the land 17.4, then 6 months prior notice ought to have been given.
Lordship.
And next is,
When in 28-1 letter, no such reference is given,
Huh?
whether notice was given or not, Lordship, nothing is given, Lordship.
nothing is there.
Nothing is there, Lord.
And secondly,
17.3 is also not given.
one more thing. Uh, 7.1, page 77. If the licensee requires any reasonable assistance from railway in
Lordship.
addition to assistance mutually agreed by the railways, then the same may be conveyed by the licensee to railway, which request shall not be unreasonably denied by railway. So he said my access to restaurant has been blocked.
Lordship.
Then he requested it, but you stopped, you did not reply as according to the petitioner. Then suddenly that is why he did not deposit it.
Lordship.
It has to be operational. Heard Mr. S. Bodhakur, Learned Counsel for the petition. And Mr. S. Roy, Learned Central Government Council. For all the respondents.
All the respondents.
First of there are in this petition, which things are in challenge here? 21, 28, 1, 2000, 106. 100. In this petition under Article 226, the Constitution, here, the petitioner has challenged and impugned challenged and challenged in an office letter dated 28/1/2026. And two office letters dated 28/1/2026 and dated 29/1/2026, annexed as Annex 8 and 9 to the petition. Post up by the impugned letter, office letter dated 28/1/2026, the respondents railway authorities has terminated the contract of operation of rail coach restaurant at circulating area beside ORH, within bracket between ramp and ORH, bracket close, at New Jalpaiguri railway station, invoking clause number 17.8, purportedly due to non-payment of license fee by the petitioner within 90 days of the due date. Full stop. By office letter, by the impugned office letter dated 29/1/2026. The petitioner has been informed that the construction of railway station building at New Jalpaiguri railway station has been taken up and is in progress. And in view of the same, in view of the construction, the space allotted to rail coach restaurant is needed. Full stop. By the two impugned office letters, the petitioner has been requested to remove all equipments, interior decor items, furnitures from inside the railway coach restaurant and to vacate the space for the railway restaurant coach. Issue notice returnable on as Mr. A. Learned Central Government Council has appeared in a separate notice on behalf of all the respondents of formal is waived. The Learned Council put a petition will furnish requisite number of extra copies of the read petition along with annexes to Mr. Day within working days from today. The petitioner sorry, the respondent railway authorities published a tender notice inviting bids for food, set up an operation of coach restaurant, come food and tea stall at New Jalpaiguri railway station. The e-tender notice dated 14/12/2000. Full stop. On completion of the bidding process, comma, and the with the petitioner emerging as the successful bidder, comma, and work order for provision of coach restaurant, coach restaurant, come food and tea stall at circulating area beside ORH in bracket between ramp and ORH at New Jalpaiguri railway station was issued on 5/4/2022 in favor of the petitioner for a period of 5 years. Full stop. On being so awarded, comma, the petitioner started petitioner. Full stop. As per the work order, comma, the railway would only provide the skeleton of the coach, and it would be the licensee who had to convert the coach in restaurants, and all the cost of conversion, comma, renovation and decoration of coach restaurant was to be borne by the licensee. Full stop. After making ready the skeleton coach as a restaurant, comma, the petitioner started operating the restaurant, and during the first 2 years of his 5-year term, comma, he deposited the what does it call?
License fee.
License fee. Full stop. On 8/8/2024, all the entry points towards the coach restaurant was closed by the railway authority, responding railway authorities without any notice, thereby, comma, prevent access to the coach restaurant. Comma, the petitioner informed the respondent number 4 on 8/8/2024 itself that due to closure, due to blockage of the access to the coach restaurant, there preventing the passengers to access the restaurant, he had to close down the coach restaurant with effect from 8/8/2024. Full stop. With a further prayer that the further prayer to treat the period with effect, treat the suspension period with effect from 8/8/2024 till its reopening should be treated for the purpose of calculating his total tenure of the contract. So the petitioner has alleged that though it was an obligation on the part of the railway authorities in terms of to respond in terms of clause 7.1B. Immediately, no response was made by the respondent authorities in the subsequent period. To stop. The petitioner, due to his inability to run the restaurant, operate the restaurant, did not also deposit the license fee for the period commencing from 8/8/2024. So it is in such backdrop, the responding railway authorities have issued the impugned office letters. It is the contention of the petitioner that as per clause 17.3, the responding railway authorities could not have terminated the contract without giving 15 days prior notice. So it is further submitted that if the responding railway authorities are in need of the place occupied by the restaurant, then the responding railway authorities could have terminated the contract only after giving 6 months prior notice in writing to the petitioner licensee in terms of clause 17.4 of the contract. Considering the fact that the respondent railway authorities are undertaking construction in and around the restaurant for New Jalpaiguri railway station. So stop. It might not be conducive. Primarily, it might not be conducive to pass any interim order, taking into consideration to interim order, allowing the petitioner to operate the restaurant, taking into consideration the larger public interest. So, however, as the termination of the contract agreement would entail imposition of penalty and forfeiture of security, deposit money, etc. It is ordered, in the interim, that there shall not be any coercive action against the petitioner on the basis of the termination of the alleged termination of the contract agreement till the returnable date.
So in the meantime, if they explore a new location, my lord,
Ah.
I may be provided.
Full stop. Tar agot likhibo. The petitioner's further contention is that as the contract period is for 5 years, comma, it is incumbent on the part of the respondent railway authorities to provide an alternate space, considering the fact that the petitioner has invested huge amount of money to convert the skeleton ICF coach, skeleton coach into a restaurant with all amenities.
11-3.
Well, it is observed that pendency of the writ petition shall not be a bar for the respondent railway authorities to explore
Alternative.
explore for an alternative location. If the contract agreement provide for such. You try, he has invested money.
Daily list for admission, item 1.
May it please, your lordship.
Yes.
My lord, the petitioner was dismissed. My lord, from the service, he was a carpenter. Now, my lord, the allegation set forth in the standing order,
What is the order challenge?
that, my lord, I'll take your lordships to the award which your lordship will find at page 30. It starts from page 31.
Jagat Dosa, management of. This TST is under whom? Private.
It's a private. Lordship.
Yes.
It's
This is
start
under
from
what?
page
2A.
30. 2A.
I have forgotten
2
all
capital
this.
A.
2A.
Yes. This section was enacted way back in 1965.
Yes.
Where any employer discharges, dismisses, retrenches, or otherwise terminate the service of an individual workman, any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of workmen party. Now, by virtue of this provision, my lord, any individual workman can come to the honorable court without making any reference.
Just the query.
Well,
As per subsection 2, it has to be made before expiry of 3 years.
my lord, just after 45 days, when you file an application with the conciliation officer, if he doesn't do anything, after the expiry of 45 days, he can come
But before 3 years.
before 3.
dismissal in 2007.
2007.
Reference is 2015,
Yes.
8 years.
Now, what is the position of conciliatory officer when he has disposed it? My lord, that is possibly not here.
Okay.
From the record, possibly we can get it.
Hmm. Yes. Anyway, that is not the challenge of the
Yes,
respondent.
right. Now, the charge, your lordship look at, I'll just take your lordship to the charge frame that is at page 16, my lord. The charge is absolutely vague charge.
So according to you, there was a domestic inquiry.
Yes,
Where after that, the dismissal order was passed.
mine.
And challenging that, you have approached the tribunal or court, tribunal under
yes.
section 2A.
2A.
Okay. This is a charge in a domestic inquiry.
Yes.
So got to, sir. Just come to a notice of amendment for a list of
On 12/11/2006,
offence.
you have constructed a kacha house in Bangalore without any prior discussion permission from the management. It has been clearly stated by the general notice dated so and so to all workers regarding enforcement of Finland. The above we proved are offences under section A of the standing order in 4. Now,
What
these
is
are-
10 to A2?
this will be, my lord, standing order, I'll just hand it over to your
Ah.
lordships. 2A will be Roman 2, my.
Conjunction.
Roman 2, your lordship will find theft, fraud, or dishonesty in connection with the company's business or property. Now, in regard to the property, they want to say, first, my lord, will have to be connected the theft or fraud or dishonesty in connection with the company's business or property.
Theft, fraud, or dishonesty in connection with company's property.
The property is here, they want to say immobile property, which my case is that since 1960, my lord, my father was in possession of this
Let
particular.
us see the procedure first,
Yes,
then thereafter on merit.
yes.
Then what did you do after receipt of this notice?
My lord, as such, my lord, there is no eviction notice to us.
No, this notice, this 16 December,
Yes.
I call upon you to explain. So what did you do?
That
You
I,
provided any explanation?
yes, yes. Explanation your lordship will
That
find
one
the
I
next page,
proceed.
page 17.
It's so and intimated I will submit my explanation, which he granted. In fact, I did submit my reply explanation in writing to your notice. Later demand on the claim that by does not find proof of receipt. It cannot be improved. I feel. As for the second para, notice I cannot but express that I feel highly to respect of my written explanation. Well, unfair. Keeping the statement of foreign right to contact and land and has been position of con. So according to you, that land is in possession of the family since the time of your father. Then what happened?
Then
After the
Lord-
reply?
Your Lordship may see at page 20, the possession certificate.
The original is to be looked into. Okay, then?
Then at page 21, the T state survey notice is for all, my lord. It has
Where
been noted-
individually served or individually served?
No, no, it is not served individually. It is hanged in the notice board.
Who has been warned? Yes, thereafter.
And my lord, ultimately domestic inquiry was held. And after that, my lord, the order of dismissal was passed. Then we
In the
came before
domestic
the.
inquiry, is it proper according to you in principle
My
of
lord,
natural
my-
justice?
My first of my argument would be, my lord, so far,
How many witnesses would examine?
the management gave 3 witnesses. And so far, workman is concerned.
Yes.
Now, only thing, my lord, I will argue, the misconduct as enumerated under clause 10 of the standing order will not attract these charges, whatever they wanted to pay. Because first they will have to show that there was any kind of theft or fraud or dishonesty in connection with the business or property of the tea state. So, Lord, obviously, my lord, there is no kind of theft, fraud or dishonesty. They are saying that I have trespassed. And if it is a trespass, they ought to have been given a notice for eviction, or they could have gone to the civil court, or they could have filed an FIR. Now, nothing all that sort they gone for. Now, ultimately, we challenge this, and the industrial tribunal passed an order against us.
In the industrial tribunal, again, parties have laid evidence.
Yes,
Huh?
yes.
Workmen, how many?
Workman 2 and the management 3. Workman 3. Management also 3. 4, no? Management 4,
Management.
including the inquiry officer.
And what is the procedure in Industrial Disputes Act?
My lord,
If a domestic inquiry is held
yes.
and an order is passed, which is under challenge, what
Right.
is the duty of the tribunal to first look at it?
Lord, if the management says that the inquiry was not proper, we may be given a chance to give a fresh evidence.
But if the domestic inquiry is found to be proper, there
Yes.
is some law.
Yes, it is up to them. As a lordship has said, there is a law that is.
That we rely upon the domestic inquiry.
Right.
We need not have to
Need not.
produce further evidence.
Right. The
Right?
lordship is
They
correct.
can say,
Yes.
or they can reserve their liberty still. That first you examine the domestic inquiry.
Yes.
If you find, tell me if I'm wrong.
Yes. No, no, it's correct.
If
my
you
lord.
find fault with the domestic inquiry,
Then
then
you can
we reserve the right to lead evidence
lead
again.
evidence. That's the position.
That's the position. Because just because he has come, Orcomen has come under 2A, Labor Court Industrial Tribunal, whether it should have gone directly to record evidence or to examine the domestic inquiry.
If it is found that not the inquiry was proper, in domestic inquiry was not proper, and if I ask for a leave, in that case, and
Whether he has examined that.
these are the things your lordship will not find.
Huh?
These are the things your lordship, I think it is absolutely.
Because otherwise, what is the purpose of two inquiry?
Yes, it's not necessary at all.
No, not necessary, unless to prolong the process, entire process. This was in 2015. Imperial order is it? I'm just refreshing my memory.
Right.
It has taken 2 years. So, whether it examined the domestic inquiry records,
They have taken a fresh evidence of the management as well as.
without any whisper on the domestic
So
inquiry.
on that, my lord. And if your lordship also will find, MW1, he has said that petitioner have been living there since 1960. And also he did not issue any letter to.
There
vacate the
is
premises.
something which because the industrial tribunal has to look into the domestic inquiry and has to make an observation on it. And if it finds it is okay,
Even in that case also, my lord, if the management want to give a fresh evidence, they may be allowed.
how it proceeded? How it proceeded before the tribunal?
Yes, let's, my lord.
Let us read the award.
Award, which starts from page 31. The workman Jagat Tosa filed an application under section 2A, the Industrial Dispute Act 1947, against the management of Motor Tea State, relating to his dismissal from his service effect from 1/4/2007. The said application is reference. According to the workman, that he was a permanent employee and worked for 20 years. His service was 1/4/7. On the ground that he constructed a kacha house at Bengali Guri line in the state unauthorizedly and without prior state authority in company's land. According to the workman, that he has been in possession of a plot of land measuring 2 acres plus 10 land covered. So, the lifetime of the forefather. The workman has a house over that plot of due to long possession, having possession certificate, paying land revenue, etc. According to him, the management no right to from his service ground of construction. It is alleged that the management brought a false allegation, waiving of land, submitted charge team, and asked him to submit his. He filed his written explanation by denying the charged allegation. The management was not satisfied with appointing an inquiry. In the inquiry, the workman was found valid. And based on the inquiry report, management is the management charge sheet against the workman dated so and so it's as follows. It has come to the notice of the management that you are alleged to have committed following offense. That on 12/11/2006, you have constructed a cha house in Bangalore without any prior discussion or permission from the management. It has been clearly stated by the general note 11/6 due to the workers' garden regarding encroachment of company's land.
I just for 2 minutes, Malad.
The above is proved the offense under 10A, that will be Roman 2, the standing order in force. I therefore call upon you to explain 18/11/2006 at 8 a.m. by disciplinary action against the event of your not submitting any explanation that you have the workman submitted his explanation according on first 6 level, but the management accept decided to inquiry of it. The workman appeared the process of the examine excluding himself in his defense. The management examined as many as 3 witnesses, but the workman declined to cross-examine none of them. The inquiry officer concluded the process of domestic inquiry and finally submitted her report, holding that the management is able to prove charges amount that gross misconduct. Management, after considering the finding punishment upon the workman, the extra service work. Thereafter, the workman filed a petition challenging the management in compliance of the notice issued, appeared and submitted the written whereby they stated that the management of the team stated 11.6 requested all the work staff, all employees, neither to occupy or encroach upon the company's land legally, nor to transfer to any other person. The said notice was hanged at the notice board of the office, also another conspicuous places that in spite of such notice, the workman illegally occupied a plot of covering random Bangalow line. On 12/11/6, management got information that workmen started the house on the plot. Management then the welfare of Mrs. So and so checked and verified. The said officer with report and making examination document submitted a report that over that plot of land. The management called the workmen to the office welfare of
Just a
Enough.
minute. What is the possession certificate? Your possession certificate?
Yes, that your lordship will find at page 21,
Just
page
21.
209.
Just a minute, just. Page on what basis they have claimed? On what basis they have claimed that this plot of land is their land?
Lord, they have said that regarding patta number 136, it belongs to the Motok Tea.
Huh? Patta number?
136.
Patta number 136.
Well,
Where they have mentioned in the search sheet, no?
Issue number 2, your lordship will find
Issue
at
number
page,
2.
at page 34. Whether the workman petitioner encroached a plot of land measuring so covered by the number 1.
Now, what is, how they have claimed that that is their land?
But that finding is not clear because MW4, MW1, they could not say very specifically. Because MW4 has said, Lord, if I take your lordships,
Because going into all these aspects is very difficult. Appreciation of evidence 226,
It's very difficult,
it is not required also.
not required.
Unless it is patent,
Your
something
Lordship-
patent.
Your Lordship's the interpretation made in the award.
That will
Yes.
go, but how they say that whether the workman petitioner encroach a plot of land measuring so and so, covered by DAG number so and so,
Yes.
under grant number. Grant, I think it is.
Estate lands are generally, it's a grant land.
uh,
Estate lands are, they're
Grant.
called special grant land. So it's known as grant land.
that possession certificate is in respect of periodic patta
Periodic, but
and tag number 136. This possession certificate by circle officer is in respect of periodic patta land.
periodic, but
Tag number 136.
yes.
Grant number 27 stroke 148. So, and it is not TP, T periodic patta. There is a difference between periodic patta and T periodic patta,
Yes.
TP. One is periodic patta and
Yes.
one is T patta.
Yes.
Now, possession certificate of the workman was issued in respect of 2 bigha, 2 katha, 10 lesser. Covered by PP number is missing. Maybe it is correct. Tag number 136 and grant number 27 stroke 148. Right. Grant number is okay. Tag number is 136. How they have claimed that this is their land?
Even the evidence given, my lord, so far MW4 is concerned, he also could not say.
Where is MW4?
MW4, your lordship may see in
I'll see from the record.
the record, your lordship time.
Said MW4. What is his name? What is his name?
His name is, my lord, Utya Kamal Sanwal. He's a lot mandal by profession.
Not full. Workman witness.
I have a certified copy.
Oh, I've got. The earlier possession certificate has been contradicted. The possession certificate given earlier in 2002 has been contradicted by subsequent Exhibit P.
Now, as your lordship has seen, MW4, he has said he did not find the name of the Motak Tea Estate in tag number 136.
It is a successor. Otog is successor to Jokai,
Joka, India.
Assam Tea Company.
Yes.
Jokai Assam Tea Company. So far as Exhibit P is concerned, the circle officer has certified that it was found that Mr. Tasa is in occupation of part of 2 bigha 2 katha 10 lesser. And it has also been clarified that our earlier possession certificate was not correct, 136, it is 15 and 16.
Yes.
That is what the Exhibit P is concerned.
Yes.
So it transfers that he is in occupation of that particular plot of land. That is what Exhibit P says. This is by a revenue staff.
Revenue.
Leaving all other things aside, this is and it consists of, I have seen also, it consists of, like he said, 15 bigha, tag number 15 consists of 15 bigha plus, and tag number 16, 25 bigha. That is evident from Exhibit M. And this is Russell or what?
Jokai.
Jokai. Jokai. And so is the management of Motok.
Motak.
Motok. Verification of enforcement. Apparently in occupation. Now, in that context, what to be examined?
Lord, whether clause 10 of the standing order attracts this alleged misconduct. This will be my, because man may lie, but the document will not. Your lordship has, your lordship has all the documents. So your lordship will go by the documents. So whether, in spite of that, whether these clause 10 of the standing order attracts this misconduct, this will be my short submission. In any case, my lord, with any stretch of imagination, but I feel that it cannot construe that the workman committed theft or fraud or dishonesty in the company's property. Will not come within the ambit of that.
So far as safety is concerned, or immovable property theft cannot be committed.
It cannot be.
Right?
Yes.
He cannot take the land from
Right, right.
Guwahati to Delhi. Right?
That
Theft
cannot-
is out of question.
Right.
Theft is only immovable.
Yes.
Forgery, fraud.
Yes.
Forgery can
can
be in
be-
respect of document.
Yes.
Fraud can be exercised.
Right. But in
And
this case,
dishonesty. What
Yes.
are the elements of dishonesty?
yes, whether
So far as though it has been discarded by the exhibit P, because exhibit P and O, exhibit O is a letter from T estate, and exhibit P is the circle officer reply, then management witness. From that, it transfers. They did not deny while explaining or clarifying about the position with regard to the possession certificate by the witness. It is for you too. That in the possession certificate, we mentioned it incorrectly as DAG number 136. It should be DAG number 15 and 16. But the other fact that he is in possession or his family is in occupation from 1960, that fact is not denied. If that is not so, right, then when this from Jokai to this has come, how it has purchased, how this land was had been transferred to, what is the name of the Motok?
Motok.
How it came to Motok's hand from Jokai? When?
Joka is the company. Joka is the company, Balon. They have 6 states.
Motok Tea Estate.
Motok Tea Estate.
They have Motok Tea Estate.
They have Motok Tea Estate.
So
And
that fact regarding his family's occupation of a plot of land belonging to the tea estate is certified by the revenue staff, and that fact 1960 is not dislodged.
But in fact, I will put it, Malal, in this way, that even if it is presumed that since 1960, for the time being, Malal, I'm not admitting, since 1960, his family is occupying DAG number 136. But here the issue.
Not DAG number 30, it has been clarified.
Not
15, 16.
It is part 15 or part 16.
All right.
Part 15.
60.
And the witnesses, his witnesses and his statement, he said that in part 15 and 16, construction has been made where his son with his family and his wife resides. Witnesses says, I'll take your lordship.
No, that's okay. But
He's witness.
the main fact is that, yes, admittedly, his family, father, maybe he himself or his wife or his son. But fact of the matter, the revenue staff, revenue document and circle officer, that is your document, that they have clarified that 12/3/2002 is in fact should have been issued in respect of DAG number 15 and 16. And in 12/3/2000, another fact has been mentioned that this man is in occupation of this land since 1960. Right?
No, I have Malal.
You have doubt. You have doubt. You will
I'll
definitely
submit.
have the right to.
I'll submit.
So,
I'll submit.
documents, so far, tentative exhibit OP MW4 then 12/3/2000. This shows that DAG number 1516 belonging to Motok Tea Estate, this man or his family or
Yes.
predecessor or successor, they are in occupation, and ultimately this occupation relates back to 1960. Right? That is what is prima facie view. Now, 10(2)A or 10(A)(2), theft is out. It is whether it is fraud. What are the elements for fraud? And what are the elements for dishonesty?
Isn't.
You have a right to respond, but so far, whatever I have read, minimum I have read, if his contention is basically limited to 10(2)A or 10(A)(2). What is this? 10(A)(2) or 10(2)A?
10A Roman 2.
10 A Roman 2.
10A Roman 2, 10A2. So his submission is basically limited to theft, fraud or dishonesty in connection with property. So far as legal recourse is concerned, circle officer said go to the civil court. Because it is Patta land. Ah.
It is not a, selling surplus land, not government land.
Government land.
It
So
is-
it
it
is
is
Patta
Patta.
land. For that, to remove him, go to the civil court.
He cannot help
He cannot help.
because it is ultimately it is tea gardens land.
Tea garden land, tea periodic patta, tea patta or whatever. So second part of that legal notice, the second part he has advised, so it is the correct process. Go to the civil court. And so far as the first part, disciplinary action, we are concentrating on that only. Come back. What is the scope of interference in 226? Case of
My lord, only
such
thing
kind of cases.
His Lordship has seen that the land was, my lord, in possession of the petitioner since 1960. So therefore, if really there was an encroachment, they ought to have gone in civil court or they could have filed an FIR. Nothing of that sort have been resorted. Now, whether disciplinary action can be initiated by the management on this issue. That is the only, my lord, small area which falls for His Lordship consideration.
Following X.
Now, Your Lordship will just see the standing order, whether it attracts clause 10 to bring in home the misconduct committed, so-called misconduct committed there. Workman. In my respectful submission, that is not.
The memory charge.
Wait a second.
What is the discussion by the in the award?
My lord, before that, can I take your lordship's Industrial Employment Standing Order Act 1946? Lord, I'll just standing over to this. To the Lord. Your lordship, look at 2G. 2G, small g.
Yes.
Standing order means rules relating to matters set out in the schedule. Now, my lord, I will take your lordship to the last page. That is the schedulement. And the clause 9, your lordship will find suspension or dismissal for misconduct and acts or omission which constitute misconduct. Now, this misconduct is set out in the standing order.
Yes.
Now, if we look at, my lord, theft, fraud or dishonesty in connection with the company's business or property. If we want to link it with the property, is either of these three will have to be, my lord, established, either theft, fraud or dishonesty. My lord, these are all missing in this.
What are the elements required for fraud?
To attract clause 10, subclause Roman 2, the first thing that either theft or fraud or dishonesty will have to be established in connection with the company's property.
Hmm.
Now, these are all missing in this case.
What are the elements of deception?
Uh, Theft, it will not come automatically. Fraud means if I make certain fraudulent element in order to show that this patta belongs to me. Now, that kind of thing is also not there. So, but dishonesty is concerned, dishonesty also not there because I have said that we have been in possession of this land since 1960, when my forefathers came into possession of land. So dishonesty is also ruled out. Our candid case is that we have been in possession of this land. So unless these three elements can be established by the management, then they can say that the clause 10, subclause Roman 2 is attracted. It can bring home the charge of misconduct.
Where is the discussion?
Lord, discussion, your lordship, to that extent, there is nothing. I will take your lordships to is 57. Finding starts from there. Page 57, paragraph 43. Now, page 43, your lordship will find the workman is not vacating their land in dispute with the house standing thereon, has disobeyed the direction of the superior authority. There is no direction, my lord. Even they did not issue any notice in order to vacate the land. So therefore,
Where is the charge?
charge is set out at
Page 16.
page
Or-
32.
Will have. Speak. So in the notice 1611, two thousand six. In it. It is not 10A1.
Yes.
It is 10A2. It is, 2 should be read as Roman 2.
Roman two.
So in a notice, it is
Yes.
numerical 2.
So numerical two, but it should be read as Roman two.
It appears everything is directed towards 10A Roman 1.
Yes. Insubordination and all that.
1 and 2.
Huh?
1 and 2.
Not 1 and 2 in your notice. Charge is under 10A2.
Yes, yes.
And how the court has seen page 56.
Yes.
Issue number 4. What the court has discussed, tribunal,
10
clause
A1.
10 of the standing order in force provides that the acts or omissions of the workman constituting gross misconduct. Clause 10A1 of the standing order provides that willful insubordination or disobedience, whether alone or in combination with another or others of any lawful and reasonable order of a superior, constitutes misconduct. He has discussed that in the case in hand, the charge against the workmen is that they did not obey the order of not encroaching upon the company's land and dismantled the Kacha house built thereon, which was the basis of taking disciplinary action against the workmen. Whereas it is 10A2,
A2.
not 10A1.
Yes.
The management has to prove the order and notice 211 not to encroach upon the company's land is a lawful order and reasonable as to constitute misconduct within the meaning of clause 10 of the standing order. The workman has all along pleaded after the date of his order he has been in position. Okay. Then paragraph 43. In my considered view, the evidence of both the parties as discussed have clearly established that the disputed land is originally belonging to the management of the tea estate, is no doubt, in which Kacha house was constructed by the workman, no doubt. The workman is not vacating the land in dispute with the house standing thereon and has disobeyed the direction of his superior authority, which amounts to misconduct. When the charge is framed under 10A2,
Finding is given on 10-1.
finding is given on 10A1. Right. This is one point. Therefore, the management is in holding guilty of gross misconduct committed by the workman is proved, and accordingly the decision of the management in dispensing the service of the workman is justified. So what do you say on that, Ms. Joinder, or whatever the charge? How it is prejudiced?
So when the finding is given,
Right.
On
So
10
you have to address on that point.
so my lord,
Because we are in 226.
yes.
Our scope is otherwise limited to an extent.
Absolutely.
Because inquiries are held. If the charge is framed on one particular direction and finding is given in another particular direction, in that case, because everything originates from the original general notice.
Yes.
Thereafter, 1611. 1611, the allegation of the tea estate is that you violated 10A2. If you read 10A2, it is theft, fraud, or
Dishonesty.
dishonesty. But the finding recorded by the trial court or tribunal is in respect of insubordination, and which is also a misconduct. So if that finding, how that finding is sustainable or not sustainable, that is what maybe one aspect which you have to, from
Right.
some authority on it, because I'm not that readily in a position to readily access.
Right, that I can, my lord, your lord, appropriate authority. Now, the first answer to
So
that
for
is-
one finding, that cannot be finding of fact. Para 43.
43, yes.
The evidence of both the parties, as discussed earlier, have clearly established that the disputed land is originally belonging to management of a tea estate, in which a kacha house was constructed by the workmen. This is a finding of fact arrived by the
Yes.
tribunal on the basis of evidence.
Correct.
Unless clearing something is there, we cannot interfere with this. And it suggests so. So it is not that we have to reappreciate, we cannot reappreciate.
No, no, that's,
Now the next line, the workman is not vacating the land in dispute with the house standing thereon, has disobeyed the direction of his superior authority, which amounts to misconduct. Now, the entire proceeding was directed in one direction, 10A2. Right? Then the finding is 10A1. There is nothing on theft, fraud, or dishonesty. It is 10A1, which is willful subordination or disobedience, whether alone or in combination with another or others of any lawful and reasonable order of a superior. Tea estate is the superior.
yes.
Manager is superior. He has given a general notice. Then thereafter, charge is framed under 10A2 on 16/11/2000. Right? Domestic inquiry in that aspect. So whether this kind of situation has resulted into immense prejudice to the workmen. It could be that, yes. It could be that or charge was framed under 302, murder, but he has been convicted for rape. Then it is complete misjoinder. But if it is 302, but converted into 304 part 1, it is permissible.
Yes, that's a different.
Right.
aspect.
Now, I'm just giving a different issue. So whether 10A2 proceeding was directed in that direction and finding is given on 10A1, that will result in setting aside of the award. You have to apprise the court on that aspect.
My,
On some authority, then it will
That-
be,
that
it will
I'll-
be otherwise
I'll
easier for me. Otherwise, we cannot go on appreciating the evidence.
that I will not burden your lordship also.
Ah.
But then your lordship will find that charge, the very basic thing. The charge will
Right.
have to be very specific.
So there might be authority.
There will be, my lord, I
Only
can,
that aspect.
I can
Subject to your reply. Let me hear Mr. Nath.
yes,
Finding of the tribunal is clear. 10A1. But when the original notice informing that you are guilty of 10A2.
My lord,
for his, other thing, your lordship. here. Now, in regard to willful subordination also, is there any order to me, my lord, that you are to vacate this? And it is also not there. So therefore, it will not attract one also. To that extent, my lord, I will assist your lordship by providing.
my lord, I'll take your lordship to the affidavit, my lord. Affidavit in opposition.
Before that, we will start.
My lord.
So far as my court's tentative view is that the finding in paragraph 43,
Lordship,
first part,
my lord.
that maybe he is in unauthorized occupation of tea estate land. Finding of fact on appreciation of the evidence brought by the parties before the tribunal. Court has arrived. So this finding of fact, unless it is perverse, is not to be interfered with.
Lordship, Lord.
Right?
My lord.
To make the matter short. Next line, the workman in not vacating The land in dispute with the house standing thereon has disobeyed the direction of his superior authority.
Yes, my lord.
Which amounts to misconduct. Yes, it could be.
It is, my lord.
Yes, I'm saying that, yes,
Yeah.
it might be a misconduct. But the journey started from 1611-2016 or 1611-2000. That you are guilty of 10A2 of the standing order. And standing order has a statutory force,
My lord.
right? This misdirection, if it is 10A1, it could, yes, that you have given notice, general notice, let us presume, earlier to 1611 on 211 or something. that
211.
All of the workmen who are in unauthorized occupation of our land is vacate. Right. Then the specific allegation was brought against the petitioner on 16/11/2006,
6.
whatever. Specific allegation.
Yes, my lord.
General will be superseded by the specific one. Now, on that count,
My lord. Lordship. My lord, I'll take your lordship to the award also. I'll also take the lordship to award. But this specific issues were framed, lordship has seen, but at page
I have
30,
seen,
page
I
34,
have
lordship
seen
has seen.
5 issues were framed.
Yes, my lord. The-
5
the
issues were framed.
issue number 3, issue number 4, and issue number 5. Issue number 3 and 4 are the main issues, my lord.
Okay,
Two.
issue number, let us see. Issue number
number-
1 is in your favor.
Issue number 2,
2 is in your favor.
2,
2 is in your favor.
Lord- lordship,
Let us
my lord,
admit.
lordship,
Then 3 also is in your favor.
lordship,
Right. Now come to 4.
4, my lord. Whether termination was justified.
On a wrong premise. You frame the charge. These are finding of fact.
Yes.
Issue number 2 is finding of fact.
Yes, my lord.
I said first line, paragraph 43. No, okay, we'll sail with you. Unauthorized encroachment. Then domestic inquiry, okay. Both parties adduce evidence, all have adduced documentary evidence, right? And court
Cross-examination.
tribunal on appreciation of evidence also found, okay, all principle of natural justice, opportunity, or the alterum partem, or done.
Madam.
Right. Now coming to the question, when the most material is that charge frame.
Termination. Whether
So
the
charge frame on when the specific original direction was 10A2.
Yes, my lord.
Now you cannot shift to 10A1 unless prejudice is common.
My lord,
Because he laid evidence that I have this possession certificate.
I'll
But the question is theft, deception, or fraud, or dishonesty.
dishonesty. My lord, we have said, my lord, kindly see, my lord, ultimately, the act or omission 10 is act or omission which constitute misconduct. That is the broader head. And under that broader head, my lord, A says that the following acts or omissions shall constitute gross misconduct.
But you choose two.
My lord, that's true, but I'm coming, my lord, I'm coming. But if lordship, my lord, come to my affidavit, the things has happened, my lord, in a different manner, my lord. Ultimately, that is why, my lord, I have to take your lordship to that. The notice was issued, my lord. This is the 2nd November 2006 notice. This was the general notice to all. Kindly, my lord, the contents of the notice given to him and the general notice, those are.
I have seen already from the original. I did not see the annexer here. I
No,
see
no.
the original. I have marked it.
No, my lord, there is one report. There is one reply to the notice because the annexure which is appended to the writ petition is not his first reply. That is why, my lord, I have to take your lordship to that. This is the notice first. Then kindly see, my lord, the second notice. Second notice we have given. To this notice, he has replied I will take your lordship to that reply.
Which annexure?
Malad, annexure 1 is the general notice, page 15, annexure 1 of the affidavit in opposition. This is the general notice. It is, Malad, therefore, we have said that expected that all workers, residents would initiate action to protect tea estate land as allotted for the purpose of cultivation of tea without any further illegal dealings with anyone concerned. We have given notice to all of them. Kindly come to next page, annexure 2. This is specific notice to the person. It has come to the notice of the management that you are alleged to have committed the following offense. That specifically we have said that on 12/11/2006, you have constructed a kacha house in Bangalore line without any prior discussion, permission from the management. It has been clearly stated via the general notice dated 2/11/2006 issued to all workers of the garden regarding encroachment of company land. The above, if proved, are offense under 10(a)(2) of the standing order in force of the state. Therefore, call upon you to explain by 18/11/2006 why disciplinary action should not be taken against you. In the event you not submit any explanation at any appointed time and date, it will be presumed that you have no explanation. Kindly come to the next page, Malad, his explanation.
Just a minute,
This is his first explanation.
just a minute, just.
Malad.
This Gayatri Bhuya is a witness. Gayatri Bhuya is a witness.
The officer, my lord, welfare officer.
Or the report. Copy, science sheet, explanation, certificate, survey. General notice, copy of standing order, notice of domestic entry, copy of journal, address, circular of it. Video address, science. Are here. And entry.
William, my lord. It is.
The Tribhuya is not a witness.
Gayatri Bhuya's report was there, my lord. On the basis of that
Which
report,
report?
she visited the place.
No, where is the exhibit?
She visited the place and in, on the basis of that, my lord, the
Ah.
management proceeded.
That is your source.
That is our source. And my lord, he did not deny. He admitted, my lord, on
No, I have asked whether you have exhibited or not. Or Gayatri Bhuya was a witness or not?
before the industrial tribunal, not, my lord.
Or before the domestic inquiry?
Domestic inquiry, I'll just check up.
Yes. Miss one.
He was not exempt.
Nobody has any personal knowledge about 2006. Your management witness joined in number one joined company in 2007. He had no knowledge about 2006. That is his statement. Anyway, yes, what you want to show?
Annexure 3, page 16, page 17. This is the first reply to the notice dated 16/11/2006 filed by the petitioner.
So, how do you prove this? On 12/11/2006, Zogot Tosa had constructed a kacha house.
Well, in fact, he said here, Malak, this is his reply,
Page
page 17, Annexure 3.
is 70. Okay,
17,
next slide, see.
This is his reply, my lord. To our notice, my lord, the annexure 17, annexure 3, page 17 in the writ petition is not the first reply. That is the second reply, my lord.
Okay, now
This is-
annexure 3, what does it say?
Yes, my lord. The reply to the notice dated 16th of November 2006, filed
Mhm.
by Jagat Tosa. With due respect, I would like to give reply explanation to the notice referred to above, in which it is alleged that on 12/11/2006, I built a Kacha house without prior discussion permission, and that a notice dated 2/11/2006 was issued to all workers of the garden regarding encroachment of company land, that such act, if proved, are offense, and that on 13/11/2006 I was called upon to show cause and last to submit explanation and last to submit explanation, failing which the matter to be disposed of on a manner desired appropriate. In view of the above, I would submit my written explanation reply in the following manner. That, sir, I have been in actual physical possession of the land in question for over 60 years without any interruption or objection except this one whatsoever. He says that in respect of the land in question, I have obtained possession certificate number so and so, dated 12/3/2000, issued by the Circle Officer Dibrugarh, and over the above, the land revenue thereof is paid up to 2006-7, and as such, on 12/11/2006, I constructed a Kacha house in Bangaliguri line on the strength of the aforesaid document. He admits, in such a case, I deny to have encroached upon any company's land. That for general notice dated 2/11/2006, other guardian workers might have been issued, but for me, I have no knowledge. He denies. At that, as regard my being called upon to explain, I would say that I received the said notice served on 17/11/2006 at about 11 a.m. and on 18/11/2006, I met you personally, explain to you why I constructed the house. First of all, to facilitate protection of other crops on the land and also to avoid inconvenience. That in view of the prolonged possession, ongoing possession certificate, and land revenue received, etc., I am sure that I have not committed any offense under section under 10A2 of the standing order in force to the estate. This is my that as for my explanation, I have been allowed insufficient time. So ultimately, the fact remains that he admits that in 2006, my lord, on 12/11/2006, he has constructed a Kacha house in Bangaliguri line on the strength of the, he says that on the strength of some document he has constructed, but the construction and the purpose of construction he admits.
Can you show from the domestic inquiry where is the charge to that effect? That on 12/11/2006. This part you have said, right? Page annexure 2, page 74. It has come to the notice, this part, because it has to be translated into that on 12/11/2006.
Yes, my lord.
Where is that? You have constructed, because he admitted,
He admitted.
then where have you framed the charge? This is by whom? Manager, not by the inquiry officer.
Not by the manager.
This letter was addressed by manager,
Yes, my lord.
and he explained, and he said, absolve him. Then thereafter, I think T Estate has appointed an inquiry
Inquiry
officer,
officer. Inquiry officer.
where he has framed the charge.
charges are not from the inquiry officer because the charges are there and he was appointed to inquire into the. I'll check.
Find out.
But in inquiry report, page 2
Enquiry report is one thing. Enquiry report, you can write anything.
Lordship.
That I can envisage the situation that you can write anything, but charge is to be framed. And he has said do you have the enquiry report?
Lordship. Inquiry report I have annexed in my affidavit also I have annexed.
Oh, okay, order sheets are there.
Yes, order sheets are there.
Let me see. Order sheets. Sheets of domestic inquiry is there. Recorders.
Yes. Very.
Fine. Indian, oh, yeah.
Page 221. These are the orders.
So, manager is the disciplinary authority,
Lordship.
manager of the tea estate, right? Manager of the tea estate. So, if that is so, then that 16/11/2006 is the charge. Right?
My lord.
This is the document 16/11/2006.
My lord.
So he framed a charge, appointed an inquiry officer, appointed inquiry officer, proceeded with the domestic inquiry, examined the witnesses from both the sides, and he is giving his finding. Charge is proved. And thereafter, termination. Then section 2A, application before the tribunal. And there again, both laid evidence.
Lordship.
And tribunal has framed 5 issues.
5 issues.
So where is the shift from 10A1 to 10A2?
But
I have understood that your projection that he has admitted that he constructed on 12/11. And he has taken a plea that it was served on me on 18/11, whatever, it came to his knowledge.
no, no.
And if the disciplinary authority has framed a specific charge on 16/11/2016, everything should have proceeded in that direction.
But in lordship may kindly appreciate, my lord. The misconduct on the part of the petitioner is illegal occupation of the tea garden land. And where by encroaching tea garden land, he has constructed a house. And there is admission, but he said that because of possession and all these things, certificate and all these things he has done, he denied that you have violated our notice. He denied that. Ultimately, that is why management proceeded to inquiry. In the inquiry, as well as in the proceeding before the tribunal, evidences are there, my lord. It is his case that he has constructed the kacha house over that particular plot of land. But he is all along claiming that it is his land of the parents are there for last 60 years, 50 years. from 1960. That is what he says.
That is what also is a fact.
The misconduct remains.
From the revenue circle officer's certificate also, which you have presented, that is a fact that his family is in occupation since 1960.
No, in fact,
Not
the,
from 2006.
No.
The construction of houses may be on 1211.
my lord, in fact, the evidences are there, my lord. That is my lord, in the award, the other parts I have to take your lordship to that.
No,
Well,
I have seen,
one-
no witness is aware of the fact of events prior to 2007.
My lord, the
Management witness.
The wo-
Documents may be different. Documents may be of existence of earlier date, but so far as your star witness MW1, he specifically said, I do not know anything about 2006. I joined in 2007. So whether he cannot have knowledge. And other witnesses are lawyers and all are others. So far as construction, you have taken me to that point rightly, that 12/11/2006, he had constructed a house. Right? Question is about vacation of the entire land, encroached land.
Walkman witness are also important. His witnesses said that the construction is for his, in that particular newly constructed house, his son, that was constructed for his son and wife resides there, and the petitioner is residing in the official.
But I admit,
Lordship.
I accept. Issue number 1, 2, and 3 must go in your favor. Must go in your favor.
My lord.
Right. I have accepted it. There is no doubt about it.
Lordship.
Right. At the same time, it has missed the observation that if we read the revenue documents, revenue staff document, that is the most bona fide one, that it had said tag number so and so, earlier said in 136 should not be there. It should be read as 1516. And those lands are also tea estate land. No doubt about it. Right. So meaning that he is in unauthorized occupation of the tea estate land. No doubt about it.
My lord, why I am my lord, reiterating, despite lordship's my lord, the
No, where is the
observation.
shift? I asked. Which I said.
No, that is what, my lord, I am trying to explain, my lord, that the misconduct is there, and on the basis of the misconduct, the entire thing has proceeded.
Right. That is why I indicated. Mr. Nath, I have indicated
My lord.
2 examples, though not very on the point, that from 302 you cannot shift to 376. That is absolutely nullity.
Cannot be.
Right.
Cannot be.
And from 302 you can shift to 304 part 1 or part B. That is permissible. That is why I have given the example not on the direct point.
My lord, my lord.
Right. I have asked on that aspect that whether this shift, because I asked you that he is the disciplinary authority. He framed the charge. So, inquiry officer does not have the authority and jurisdiction to reframe the charge. That you should be proceeded. Why? You explain why you should not be proceeded under 10A2. Disciplinary authority is very specific. Inquiry officer, his brief is limited. Right. That is what I need an answer from you or from Mr. Dotto. Because we are not going to appreciate all this evidence.
My lord, my lord.
Right.
Fact.
Nitty-gritties and to substitute a finding, all these are not
Lordship.
within the
Lordship.
scope of 226.
226. That's
Right.
true. That's true.
We are on the broad facts.
Lordship.
So that is why I
Lordship.
need an assistance,
Lord-
not
my lord-
into the nitty-gritty.
My lord,
Where you have shifted,
my lord,
and
only
this
to-
shift is permissible or not
my lord, only
within
to-
the contours of
Lordship. Only to,
disciplinary proceeding jurisprudence.
only to appreciate that's true. My lord, only to appreciate that whether if there is any shift, whether some prejudice has been caused to the petitioner, because if the charge is not there,
Prejudice is caused, but whether that prejudice is material or not.
my lord, here is a case where the entire thing that is his explanation, and it went in that direction only. So no question of prejudice is there.
Because
I'll-
his submission is on 10A2.
Like, the misconduct remains. Malad, ultimately 10 is regarding misconduct.
No. That is why the, I think, rule of law, quote unquote, is there. That once you have proceeded in one direction, and when you are about to reach the destination, you cannot change the direction to reach another point, because you are going to Nagaon. That is the direction initially, that is 10A2. Then the tribunal also, he has shifted to 10A1. When the disciplinary authority's mandate is that you are being proceeded with 10A2. That is what I said all along. Otherwise, we are not concerned with other facts, reappreciation of evidence. We are not going to substitute.
Malad.
Right, patent illegality is the only thing, I think.
Yes, Malad,
Right.
if they
And
already.
this shifting could be a patent illegality or not.
Malad,
Could be, I said.
logic.
Meaning thereby may not.
May not.
So,
may not.
Mr. Lotto, you have to show me. Otherwise, if disciplinary authority has directed the driver, that is inquiry officer, to go in that direction. Right? You go in that direction and establish the charge under section 10A2. Right? Whether it is permissible for the inquiry officer, he has not said anything, proved. Misconduct is
He has
proved.
said misconduct is proved.
In that situation.
In fact,
In that situation,
under
and the tribunal also being a judicial authority, right? He framed 5 issues, and he has to take into account the first charge, whether his observation regarding 10A1 is permissible. That's all. Have you understood my point?
yes, Madam. Absolutely, Madam.
That is the only thing
Yes,
you
absolutely,
can
absolutely.
apprise this court. Otherwise, we are not going to appreciate all this evidence. Other materials we will look into.
Gotcha.
Nobody has personal knowledge about 2006, but he has admitted in his reply that on 12/11 he had constructed the house. On that basis, this line may have a material effect or not, 10A2
Yes.
in the charge framing order. That is all. Otherwise, anything to be further to be looked into in the record? No.
I don't think, ma'am. This is the only area, my lord, I'll try
Only
to
area.
satisfy. you.
And if misconduct is proved,
Misconduct.
let us assume for a moment. Suppose misconduct is proved, not on the charge which was framed, but on another charge which was not framed.
But dishonesty is also dishonesty. Even if we say
Dishonesty
dishonesty is proved,
Dishonesty is too big a word, but I can address that. I can
dishonesty-
address that. If you want to insist that it is a case under 10A2,
Malad,
then it is very well for me.
10A, 10A2,
10A2, if you
10A1.
make your submission on 10A2, it will be very
10A2,
convenient for the court.
10A2 and 10A1, Malad, is also both are there.
No. That is why I have said,
Both are there.
please address on this point.
Malad. Logic. I have
My example is not to the point, right?
I have to.
That
While
302 shifting to another offense may not be correct. Yes. 420,
Malad, here
420, then you shift to 406.
here
That is again gone.
here kindly I just like to indicate, kindly see, Malad, the notice was a charge which is on 16/11. that is Malad, before his reply. That is before his reply. We have broadly said that there is a notice if someone violates, Malad, page
That is
60.
why I put the question. Who is the authority to frame the charge?
The manager, Malad.
Manager, he framed the charge.
He framed the charge normally what happens, Malad, after a show cause is given, Malad, after having the knowledge of the what has happened, then only show cause and charge is given that you have done so and so. Well, so here we have given and after he, whatever he has replied and taking into all these things when we proceeded in the inquiry, well,
It is why, Mr.
He was-
Nath, I have asked you the specific
he
question.
was asked to,
Because what he says in the order sheet on 15/12/2006, the enquiry officer, that is why I have asked the specific question. He said, I have explained the charge to the workman to which he pleaded not guilty. There is no whisper about the charge in the
In the-
enquiry report, order
in the,
sheet.
in the inquiry report, first one paragraph he has
That
put.
is not his, there is no signature.
No, in the inquiry.
He can prepare in his advocate chamber, the inquiry report. But question is in the order sheet, he said, I have explained the charges to the workman to which he pleaded not guilty.
Well,
And in the inquiry report which he has typed,
in the inquiry report,
he said the case in brief is that
copy
there
of
is
the-
no mention about 10A2.
copy of the charge sheet, according to, this is the charge that on 12/11/2006, the workman has
That
constructed
is
the
what
Kacha house.
Mr.
That is the charge.
Then exhibit B. That
That
is
he
a
said,
charge.
the charge were read over and explained. That is the charge. I'll take your lordship to that.
Which one?
I'll apprise on that, Malad.
Okay. That too.
Am I allowed to mention matter, Lordship?
Yes.
Lordship, it's item number 11. If Lordship, this matter is over, I believe I am not disturbing Lordship. Lordship,
Yes.
seeking a adjournment in this matter, I want to presently be there. I was unable to appear physically due to some my physical personal.
Yes.
I've apprised the opposite counsel. He has given a no objection for that.
With made a prayer, you are for the petitioner,
I'm for the respondent, Lordship.
respondent.
The local counsel is there from the response side.
Okay. Who is the prefer? You are making prefer adjournment or what? Yes. Respondent, yes.
Yes, Lordship. I'm just making just a small accommodation, Lordship. I'd like to be physically there to argue this matter.
Yes.
This could be in this 20th February or 26th February, Lordship, as suitable to Lordship's calendar, Lordship.
Hello. Okay. You are Mr.
Anurag Lakhotia, Lordship.
Lakhotia, with the
What is
current counsel for the respondent. Listed by Ms. Kaidas. Consent. We'll look into it. You agree? We'll look into the date, right?
Sure,
In
Lordship.
consultation with Ms. Aidas,
Sure, Lordship.
and thereafter fix the date. We'll put the date.
Highly aware, Lordship. Highly aware.
Malad, I have a submission, Malad. At 2, Malad, there is a special, Malad, there is a bench, Malad.
Okay.
But I have
Thereafter
requested-
tomorrow. Aji ki tarikh, aji ki bar.
Malad, we have discussed, if not inconvenient, can it be on Saturday, Malad? Saturday is a whole.
Not Saturday. I might not be available also. Next Tuesday?
Lordship,
Oh, wow, I say.
just that. Lordship,
Can it be? Okay. Let it be on 17 then.
17.
17.
Malad.
By Lordship. Can it be on 18?
10, 12, some problem. 19, it is for okay for
Actually.
19 for it.
Malad.
On this, only on these
Only
two
that,
aspects,
Lordship.
Area is very small now.
small now. Otherwise, this evidence reappreciation is not permissible for the court. In this part of the hearing. Can
Extending
it be
order.
kept?
Yes, it is a part, it is a part. There,
That
it is available.
industrial order.
Yes, it is exhibited. It is exhibited, Malad.
No, loose is better.
Malad, Malad,
It's handy.
Malad.
As Dr. Senior Counsel. Said by Miss. For the petitioner, the Nath Landed Council.
Number 1, Malad.
Is the case. Let's the case again on 19.
19.
19-2.
18 will be difficult for.
No, but in the second half can be possible. because motion would be there. Motion would be there.
Right.
We cannot stop.
19th already, 2 matters are already fixed. So,
Okay, well, we'll accommodate if required.
right, that's a,
Only on the small point.
yes, yes,
But not on motion day, it will be difficult.
right.
Because motion day, my
I can understand.
mind is also,
Occupied.
Grateful, Malad.
Recently, we have mentioned a matter before court number 5. Now, we have been informed by the registry that it is a matter of court 4. So we are praying that the matter may come up to
what is the motion?
motion.
Okay.
Much obliged.
May it please your lordship.
In this matter, I was supposed to seek an instruction, my lord, from the directorate, my lord. My lord, I need some 3 days time, my lord. They are giving me the instruction,
He has got the instruction, probably it's not in the written form.
not in a written form. That's, my lord, because
Okay.
A short date be given.
for
because
the,
I'm
my lord,
suffering, man.
next week, my lord, may fix it on Tuesday, my lord.
Otherwise,
have-
it's covered.
Okay, Mr. B. Sharma, learned counsel for the petition is present. Stop. Mr. R. Dhor, learned standing counsel, handloom and textile department has submitted that he is awaiting further instructions in the matter. And in that view of the matter, he has sought listing of the case on next Tuesday.
Tuesday.
My lord.
Okay. A request made by Mr. So is allowed, list the case accordingly on so Tuesday.
Much.
Lordship, the matter pertains to non-release of my security deposit.
Who is the respondent?
Lordship, it is the PW department.
Mr. Dhor. He has gone out.
Lordship,
Call somebody.
Lordship.
Item number 5.
It is again a blacklisting, my lord. My lord, must see that a few clauses, my lord.
Who is the, who is appearing for the respondents? Respondents.
After that, I shall inform him, my lord. I'll inform him. Your lordship may just see the code.
Let them come.
MSC. Lord.
Health department.
Health department.
Legal services.
I will, they filed the risk.
Yes, Mr.
Health. Lordship, this, I'll intimate to the counsel who is assigned to this case, Lordship. Can this be, may matter be taken out after some time? No, it is counsel DP Bora who is doing this matter.
Yes.
Okay, okay.
That is right. I'll just intimate to him, Lordship.
Is he available?
Yes, Lordship, after some time. Lordship.
Or should I
Must-
place, my lord, only the clauses, my lord?
Let him in his presence. Again, he will.
Because
Yes, Lord.
again, another matter, my lord, if wrong matter is taken up, my lord, that is by my lord. Because
Because it should be in presence.
no
Call him,
intimate
we
is
can
there.
wait.
Lordship, may give me 2 minutes. I'll just intimate. Much obliged, Lordship.
Take your seat. Yes.
Well, this is also a red contract, my lord. My lord, here the red is firm. My lord, if your losses will take the additional
So it
affidavit.
take me from the very beginning, otherwise it will be.
So beginning, my lord, I'm just coming. That is farm rate that has been given, my lord, in the 872, my lord.
No, no, take me from the sequence of events, otherwise it will be very difficult for me.
My lord,
Pick up something from somewhere.
no, this is a contract.
No, take from the very beginning, how the
All right.
things are proceeded, otherwise it is very
Well,
difficult
well.
for me to pick up somewhere,
My lord,
something from somewhere.
e-tender was issued, my lord, for supply of drugs by the MSL. Point of delivery has been shown, my lord, at page 45.
Because Mr. Sawala, I understand very slowly.
Yes. No, I shall go slowly, man. No problem. That
Where is the NIT?
page 41, well.
This is for supply of essential drugs completed between for a period of delivery. Central for procurement. Yes.
Now here, my lord, in the tender, the point of delivery has been mentioned that at page 45.
This is for what? Supply of
Medicines.
essential drugs to various medical health facilities and the
Well.
Department of Health and Family Welfare and Medical Research and to establish a framework agreement with manufacturer. This is for 3 years.
Yes. And at page 44, my lord, you will also find the farm rate,
Which is a ratio.
clause D.
Structure. Contract rate.
Yes.
Contract is completed.
It is found, my lord,
Their
from
price
all
against
sides.
specific
Till
employment shall code the taxes. After empanelment, what happens?
after amendment, when purchase orders are being issued, my lord, from time to time.
No, this indicates different D contract rate, farm rate.
Farm rate.
After the empanelment process is complete.
Yes.
And the empanel manufacturers are asked to submit their price
Price.
against a specific procurement, then empanel manufacturer shall quote the rate.
Yeah.
For each of the items it intends to bid for. Again,
Yes.
bidding
Yes.
or what?
My lord,
Again bidding after
Bidding.
empanelment.
after virtually it is written.
It is there.
Yes. Bidding.
Bid with condition variables shall not be accepted. Delivery shall be made at the location as stipulated in the purchase order placed with supplier.
Bid with contract.
The
Variable that will
rates
not be
are quoted, accepted, and contractors shall remain firm and binding on the bidder. Any increase in the price will not be entitled to the completion of it. No bidders shall be allowed. Control price. Okay, delivery and inspection, what do you want to show?
Yes, delivery inspection, my lord,
Shall
point two.
remain formed for
Point two,
the
my lord.
contract
If it
period.
is less than equal to 1 lakh, then it is
Cross
delivered centrally.
Conditions subject to availability.
The order items shall be delivered
etc. when are received. Will not be
at
considered
dark warehouse based on Guwahati.
subject to available so and so in a very particular or any circumstance. Even use shall be clearly- Ordered items shall be delivered at the ordered state drug warehouse based on for different drug stores, medical college stores located. And the instruction you from the date of then if it is less than 1 lakh,
Yes,
Guwahati,
equal to 1 lakh
Guwahati.
also.
Guwahati.
Guwahati, centrally.
And if it is more than 1 lakh,
Then in the different places, my lord, where it is
purchase order will be placed on a
different districts.
purchase quantity is less than cap or less than injection in one supply,
Different-
other supply is
Yeah.
allowed. State tax, manual fee. So delivery period is what? 60 days.
Yes, my lord.
Delivery period?
60. Some orders 75 also, my lord. Guwahati, it is. Now page 47, my lord, that is the department blacklisting clause.
Non-supplier complete supply by the approved manufacturer within agreed delivery period. Additional penalty period. Delay. If there is delay in delivery, we understand penal deduction. Yes.
Now, my
Page
lord,
47.
page 47, my lord, just page, my lord, that if any default is there,
Huh?
first, if any
Oh.
default is there, then first, my lord, that contract is to cancel. First step. Your lordship has got it, my lord. The 6th line, then concerned that contract shall be cancelled. First step is that contract.
Hmm.
Then second step is the product will be debarred for 5 years.
Farm will be, farm
Hello?
will be debarred.
No, well, it is
The manufacturer, importer,
shall be
farm.
debarred for participating in any bid called by the authority for 5 years from the date of debarment for that item. for that item.
Ah.
only. So it is product department. This clause is for product department. So suppose there are default is in the set of 5 items, then 5 items will be debarred. If one item, then one item will be.
Product department. Yeah. So in case, come with supply.
Supply of 90% or more than the order
So
quantity,
many
and but fails to
farm.
supply the entire quantity within the allowed period, then farm shall be levied penalty of 10%. Suppose any farm completes more than 90%,
Contract.
then only
concern.
penalty will be levied, then there will be no debarment. So 3
Concern.
points are there, my lord.
In case,
Then 2, farm debarment.
yes, in case there is failure or non-supply of
Yes.
90% of the concerned product,
Yes,
then that concerned rate contract will be cancelled.
cancelled.
And farm will be debarred from supplying that item.
Yes, only that product, that will be product debarment.
Yes.
And then second one is the farm debarment.
Huh.
The farm shall be blacklisted and debarred from participating in any tender
Hmm.
by the TIA or procuring agency for a period of 3 years if the company is debarred for all items where it has RC red contract for less than 3 items, or at least 3 items where it holds RC red contract for more or equal to 3 items.
Hmm.
So suppose that contract is for 3 items, then for all the 3 items she must be debarred. Then only the farm can be blacklisted. If it is more than that, also there is no problem. At least 3 items must be there. If less than 3 items in a contract, then that suffices. So this is the matter of the. Now, if your lordship will see, my lord, it is the managing director who is authorized to take a decision, my lord, only. That is at page 67, my lord. Agreement starts at page 63.
What is this? Page 49?
Letter of intent, my lord.
Where is your name? What is the petitioner's name?
My lord.
Protect.
127.
127.
27.
61.
And what is this letter?
Letter of intent, because I have been, farm rate has been, my lord, farm contract has been
Allowing
given.
for entering framework agreement, your quotation, reference to the, sorry, MPanel.
Yes, empaneled.
Duration of rate contract, 3 years. 3 years.
Then contract is also there, my
3
lord.
years. Scope of work per item, delivery period 75 days from the date of issuing the order. Deed of agreement.
Yes.
Deed of agreement. Security deposit. Test report, product sale type, penalty. Unbatch, batch. Okay. Same thing is repeated here.
Yes, yes.
Product department and
Same thing. Same thing. Now your losses may come to, and it's at 3 page 63, my lord. This is, my lord, the agreement, framework agreement. for
page 60.
63, my lord.
3.
This is to be signed, my lord. Page 64, it starts.
And
framework
it
agreement.
is reference to your duly filled sign agreement. Sign agreement. Okay, this is the agreement.
Now here, my lord, only I want to rely on page 67, clause 8. That is the managing director who is authorized to take.
It was entered into 31st July. Page?
Page 67, clause 8. It's the managing director who is to take decision. That will be fine.
So you quoted for these items.
Yes. Yes, page 68.
Hmm.
It will allotted to me. Capital.
Manufacturer, importer, allowance kindly.
Several items are there, brother. About 67.
Yes. Yes.
My lord. First notice they have issued regarding default. Page 70. No suppose.
One minute.
Similarly, my lord, other
Just a minute.
letters are given.
Just a minute.
Your losses perceived page 79.
Just a minute. Page.
79, my lord, this is another notice for default.
First is 74.
Yes,
74.
yes. Now 79, my lord.
74.
Yes. In this letter, I want to show, my lord, one sentence, the page 80.
And is
Page 80, my lord, the last sentence you'll also see.
what?
This letter has issued.
So things started from 27.
Yes, my lord.
27, 2024.
24.
Yes.
Page 79.
By the time highest limit you have already exceeded.
Yes, ma'am.
90%. 76.
This is
Percentage,
from one,
percentage less than
Yes.
G.
one purchase order, my lord. So.
This
there are
was page 79 on what date?
79 is 12/9/24.
12/9. What did you say prior to that?
Yes.
In page
My lord,
77?
I is at page 81.
Page 77.
77. 77. Yes. And from that, pending and quantity of the so and so, in complete quantity of so and so, has been initiated and materials lying at the transporter's warehouse, which will start delivering tomorrow. To assure that supplies for both purchase orders will be completed.
Complete
So,
format.
in the given direction.
Interior company. Yes, page 79.
Yes.
Which line?
Page 79, page 80 last set.
Page 80.
This letter has been issued
Excess expenditure.
as per approval of the managing director. Because I've shown that clause 8, my lord, that's the managing director who is the type.
Balance. What is this letter says?
Notice of default.
Notice of default. Final plan. This is in respect of two products.
Two products.
The earlier was in respect of many.
Two purchases.
Earlier notice 76, 6.
Yes.
These are common or what?
No.
Or different?
Different. Purchase orders.
Different.
Purchase orders.
These are different.
Different.
In 76 out of 6, 4 were 0.
Yes.
Hmm.
Now these are different.
Yes. Next.
Now similarly, my lord, then
What is your reply?
83 month.
Extension of time. Your reply is extension of time.
Request for 7 day time, so and so.
Not to proceed with any debarment.
Yes.
Action with applicable LD charges. For supply of
84. That is. That's the
supply
actual-
of
This letter was also issued with the approval of the managing.
how many products here?
Here, extension only.
Five.
Purchase orders is.
These are common or separate?
Separate, well, here more purchase orders are there.
Carbo. And,
If you'll also see the. purchase
no,
order.
all these are separate or in continuation of one another. Separate product.
My lord,
Come to page 76.
Yes, page 76 is.
There are 6 products,
Yes.
6
and-
items.
Yes, my lord. That
Now,
is re-
next is another letter, page
That is
79.
two the separate product, but 86 is in respect of 76, connected with 76.
76.
Yes, my lord.
5 products.
70
76 and 86, my lord.
or 76.
Yes, my,
This is specific to 76.
yes, my lord.
For one product, well, there are 7 purchase orders. 7
No, no,
purchase
no.
orders.
Because there are 2 separate compartments. One is product department and there is another farm department,
Farm demand.
right?
Yes.
Yes,
That is why page 76, 5 products, and this page 84 is in continuation of that.
Yes.
yes, my lord.
5 products
5 products, something has
supplied.
carbo 0.5%. Something has been dropped.
Yes.
Yes.
Which one is dropped? Out of 6, 5 remained.
Carbo.
Which one is dropped? Which one is dropped? Trene.
My lord, yes, some other products.
These are separate products or what?
No, my lord, All are related, my lord.
No, no, items are different or common.
Common, my lord.
No, purchase orders are different, my lord.
No, same person.
If your lordship.
Same purchase order.
Ah,
3, 4, 5, 9.
ah,
Oh, purchase order different.
Purchase order maybe, I don't know, unless you say
right.
36.
Different purchase orders. One is common, my lord. 459 is there. Six zero four is there. Two are common, my lord. Others are
1 and 5 to same nige.
that also same thing, my lord. This data is issued as per approval of the amending.
Whether page 99 is consolidated.
Exactly.
Perhaps it is consolidated.
Yes.
Mr. Bora,
Yes, my lord. I am checking, my lord.
No.
Approval date.
because page 99, so many products.
So many products, but approval dates are different.
38,
Yes. That's approval dates are
total
different.
number 38.
Yes.
Percentage of deliveries are given
Yes,
and delay period is given.
my lord.
Delay passed since approval. Those are given. So out of 38, maybe 90%, 1, 2, 3, 4, 5, 6, 7,
Number
9,
1.
10, 11, 11, 90%.
Yes.
Rest 26, less than 90%. Yes.
My lord, yeah. That is in one my lord purchase order, they have said, but last.
I have
my lord,
seen 38 item, separate purchase order,
Yes,
separate approval date.
yes.
All these are maybe one.
My lord.
Yes. Next,
Next, my lord, 101, final stoppage office.
final so. Okay, let us read.
Here, my lord, the losses may just see the.
No, let us read total.
Yes.
Cannot pick up 9.7. This is 21 for 2020. Okay. To inform you that your listed annexer 1, which Yes.
So this
There's how many items mentioned? 9.
items at 9 are, product is not 9. Products same are repeated, some purchase orders are different. So one purchase, one item can be purchased, 7 purchase orders.
He said,
So if you're also
said,
item number 1,
I am to inform you that your company was awarded with purchase order by PO number placed at Annexer 1.
yes,
That is what he said.
yes. Now if you're also see
Delivery status.
at page 103,
Ah.
item number 1 is repeated, my lord, here. Item number 9, same thing. The purchase order different.
No, that is purchase order date is different.
Purchase order different.
Yes.
Item is same. That item, my lord.
Item may be same, purchase order is different.
Purchase orders are different, but in
90 days delivery period, 75 days delivery period. Whatever is it is
My lord,
purchase order specific.
purchase order different.
It cannot be mixed up.
And moreover, this so-called notice, my lord, there is no mention that it is with the approval of the managing.
So that is why you did not reply.
No, not that, my lord.
Is it so?
We have it, my lord. Except reply is there, 105.
Then again extension.
Yes, my lord.
Yes. Again,
What date again?
107.
This is 21/5. 21/5. Again, extension is what? 17.
Yes.
What does it say? Extension to complete a pending supply. Your committee was awarded.
Here say, my lord, extension of 7 days to complete the pending supply, failure to which lead to product development.
That is already mentioned 21/5.
Yes.
Remain unchanged. Yet complete the required supply. Okay. Third so when is the first so-cause?
My lord.
Second so-cause.
71, yeah.
Second so-cause. Yes. So-cause notice.
No, that is notice for the, not so-called, my lord.
6-1.
That was not
He
so-called.
said first so-cause, second so-cause, third so-cause.
Well, these are only notice for default.
No, this one is he says,
Yeah.
let us see again. Final so-cause, that is 101, 21/5,
Yes.
21/5. And he says second so-cause notice, 7-3, let us see. 7,
6-1 and 7-3.
7-3.
6-1 and 7-3.
So where is 7-3?
Okay.
7-3.
So it's not there. 6-1 is there, my lord. 6-1 is there.
6-1,
page
which
90,
page?
page 91.
6-1 is which page?
91.
90.
This is also, my lord, not a so-cause. This is not so default.
No, that is the number difference. That is not annexed. Page 9, come to page 107.
Yes.
Second para.
Well,
Hence, so-cause notice issued by letter number 509791,
yes.
8773. That is not annexed.
No, not. Now, 701 is.
There is a second, first so-cause notice. That is 509791, 8773, dated 6/1/2025.
Yes.
That page 91 you have annexed, that is
Yes.
notice for default.
Yes.
And 7 days time. But there is so-cause notice.
Yes.
Then there is a second so-cause notice,
Yes.
which is also not annexed.
No, first is there, my lord.
No, that is not the one. Come to page 107. Second para, sir, madam. Then
as per
First, last line of second para. Hence, so cause notice issued by letter number 509-791-8773.
yes, this is
Turn
there.
to page 91.
Well, I'm just
I say only after examining the document. So first so cause notice, second so cause notice, not part of the writ petition. Am I clear?
I'm just 1 minute.
Which the court
The first-
has not been able to look into. And this is final so cause notice or third so cause notice. Earlier two have not been annexed. It is a bulky brief, so is it available?
That
In the first one, I have not seen the first so cause notice, second so cause notice, because whole case hinges upon no so cause notice, leading to debarment.
not there. They are not there.
They have categorized the letters in two different departments. One is show cause notice, other is notice cum extension. So we have got the notice cum extension copies, but not the show cause notices except final show cause notice. And we will only proceed on that basis.
Yes.
And that might go against you. Am I clear, Mr. Sayawala?
I shall come.
First so cause, second so cause is not part of the brief. And that may go adversely against you. Might go. Second so cause notice is not part of the record. Then third so cause notice, 509-791.
All the
Third
extensions are granted.
third is part of the record. 101. Yes, what do you want to convey?
Then 117, my lord, again.
I have looked into it.
Yes. Then again, extension of 7 days. Which is at page 1. Then again, final notice. That's page 130.
Fine. It is 99. Mr. Bora, what is the meaning of final?
Yes,
There can be final after final.
my lord, on their request.
We don't
again-
see in tournaments that one final is held
Yes, my lord.
unless it is washed out
My
by
lord.
rain. There cannot be a second final.
Yes, my lord.
So
Although
why in your case final after final?
they decided that to be final, but on their request, my lord, again extension was granted. my
What
lord.
game you are playing?
Because on their,
We don't
because, my
know.
lord, the government wants that in government hospitals, there was scarcity of medicines. So once new process will start, my lord, then again will be, so they were given chances after chances, my lord. That's why even after final notice, my lord, they were granted extension. So that medicines can be obtained, my lord. Because otherwise,
Okay.
they are always there in the government hospital, there was hue and cry that, my lord, medicines are not available. And it is because of the default on the part of the suppliers,
So-
my lord.
Even if so cause notice is served, it can be that period for supply can be extended. Is it the provision?
Provision, there is no such provision,
Maybe
but
there-
they
there
were
may be
given the
because you are
chance, my
dealing
lord.
with essential drugs.
Yes, my lord. That's why they were given the chance, my lord. So that because every time they were saying that it is in the warehouse, it is in the transit, it is with the courier. So, my lord, on their request, when they approached us saying that within 7 days, 10 days, they will deliver it. So we granted them the,
Delivery inspection.
all are, my lord,
They
essential
deliver
drugs, antibiotic or the other things.
And all these
Delivery.
stockholders are things are issued by the general manager, my lord. There is no written that the approval of the menu. As written in the 2 letters.
But the impugn order has been issued by the managing director, my lord.
Fine.
In fact, my lord, after issuance of the debarment notice, they filed one representation, which I
One
have
minute, 1 minute. Okay, we have reached 117.
117
17.
years.
Thereafter,
122 reply.
Because 120 to another reply, because of this kind of assurance, my lord, they were given the extension, my lord.
then again final notice.
Again, final.
Again, not final
Huh?
notice, notice come
Page
extension,
131.
Some extension.
123.
Nomenclature does not change.
Because, my lord, medicines are required. They are saying
Right.
that it is there, my lord. So we gave them the chance that, okay, fine, supply. If they could have supply within this time also, my lord, the debarment doesn't come.
Now where is the impugn order?
Yes, fine.
After this extension,
That 131, my lord, you'll also see final notice.
That is, they have categorized into two. One is show cause notices, the other is notice for extension.
Yes. Now here,
They have that could be seen easily.
yes, here also, my lord, there is no shortage.
Not required.
Yes,
1, 2, 3.
yes.
3
Now-
already done.
yes, ma'am.
3 already done.
And on their request, only the extension were
And
granted.
the charges were made clear.
Yes, my lord.
And your reply is also there.
Yes.
Please extend.
Yes.
Actually, we have supplied, my lord. I shall come to that.
That is
Not
a
even-
different issue.
My lord, I shall. There is, my lord, some
Again,
From-
7 days.
debarment is at 136.
Debarment.
No, final 7 days extension at page 131.
Yes, that
I have seen.
Yes, my lord.
I saw.
Debarment.
This is not,
Show cause notice.
After one-
Extension, show cause notice. The difference I am to. Authority, extension.
now in the debarment, my lord,
Yes.
the third para, your lordship. 1 for 37.
Yes.
Other extension has no valid ground to consider the only final is come extension order was clearly mentioned that last communication and upon non-communication desired supplied products per product farm department will be proceed as per so and so. The detail on portal details as on that. Well, portal there is some mistake. Well, a total non-supply of 13 number of essential drugs against 17 number of POs where 11 POs were found to be below 80%, has not been started. And one PO not started, and tender norms fail at minimum 90% of the supply obligation to be fulfilled for incursion admission penalty. Therefore, in the greater public interest, your company so-and-so is hereby blacklisted and debarred from participating in tender. There is no termination of the that contract nor conduct department. Now, my lord, we have submitted a letter 2411 saying that various items, my lord, mentioned in the department order, already we have supplied, delivered. Some items were reviewed by the authority.
No, tell me whether these facts they have said in on page 137.
Yes,
Third paragraph,
yes,
right?
yes.
That they have given a status from some DVDMS portal.
My lord,
I don't know what is DVDMS
that
portal.
is a portal, my lord. where-
Status as on 14/11/2025. They have said that total non-supply of 13 number of essential drugs against 17 number of purchase order, where 11 purchase orders were found below 80%, 6 below 90 but above 80, and 1 supply has not started. If this fact is disputed,
Absolutely incorrect. Absolutely incorrect, my lord. Because if your lordship will see,
as on 14/11,
yes, as on 1411.
what is DVDMS portal?
My lord,
Correct.
that is drug,
DPMS portal, my lord, everything does not come.
drug and vaccine distribution management system.
Is it somewhere part of the
Yes, my lord, page 139, my lord.
page that I have seen? I have marked.
Yes, my lord.
Is it the measure to is it the yardstick?
Yes, my lord, that is the
Where,
portal
where?
where, my lord, every delivery is recorded, my
Is
lord.
it mentioned somewhere in a agreement? For me, it will be easier.
My lord,
My lord.
sometimes, my lord,
DVDMS.
Yes, my lord.
sometimes,
Tell me.
sometimes portal gives wrong, my lord, yeah.
Maybe, but if it is that is the standard, then
No,
it's the standard.
No, no, my lord. Your
No,
lord-
let me,
I
I asked him.
I shall show one order, my lord.
I have asked him,
Yes.
is it part of the tender process or bidding document or something?
Yes.
Because you have resorted to DVDMS.
Yes. I shall show one example, my lord.
I'll let him respond after we'll look.
I shall show one example that this is not correct, my lord. Their status is at page 237, if your lordship see, 257, if your lordship see. Xylometazoline nasal drop. 57.
What is your reply first? 140?
Hello?
140, page 140.
One. Yes. 140, we have given, my lord, the details, my lord. That these are supplied, delivered. And somewhere, my lord, refused, they have said. Delivered. Entire quantity. In Sonitpur, my lord, that part has been refused. In Albury also they refused.
Which you have come to page 192.
192,
Uh,
yes. Thank you. These are the, my lord, documents,
Purchase order.
170, my lord.
Page 97. Purchase order. Purchase order.
Yes,
Wait.
this is the bill, my lord.
Manufacturer supply order.
And the next one is the supply copy, 190, by which we have supplied. In this way, my lord, we have given all the documents. Along with the bill, we supply that. To that copy has been. And my lord, one document will make it very clear, my lord, if your lordship will see in additional affidavit, one letter we have given annexure A, that will make everything clear. How much supply we have made. Order number and supply, everything is in there.
Is there any reply to your representation?
No.
My lord, that reply to the representation, we have stated in our affidavit, my lord.
Okay, okay,
That has been considered, my lord.
okay, okay.
And your lordship may just see, my lord,
Okay.
one page in my additional affidavit. We have given the consolidated, my lord, how much we have given. Applied.
Yes, which page?
Page 849.
Page?
849. Additional affidavit.
849?
And
Of
exact-
these extra files?
Yes. Additional affidavit.
Huh?
Additional affidavit. Additional affidavit. 3012. Because
Mr. Bora,
Yes,
in
madam.
the representation, they have said in most of the project delivery status is 100%.
Yes, my lord. So we have in our affidavit, my lord,
Okay.
your lordship, we have dealt with that representation. After they filed the representation, we have sought for again reports from all the concerned districts, my lord.
Okay, okay.
And that we have dealt with.
Okay, you
Yes, my lord.
should
And-
respond to it.
Yes, my lord.
Annexure A will show the, my lord, entire picture, my lord.
This
849.
picture is by whom?
We have, my lord,
Petitioner.
supplied. We have supplied. All the documents
Petitioner.
are there.
No, no.
It
This
is a
picture is projected by whom? Petitioner?
petitioner.
Petitioner.
Okay.
My lord, all the documents are there, my lord. We have- My lord, because the product it we seen, the sales order may be different. In the item number 1, 2, 3, 4, 5, These are the same
No,
product.
we are not going to calculate, sir.
No, no, we have given the, how much delivery is given.
I have given in your representation,
Yes,
right? At page 160, you
Yes.
said that, say, delivery supply is 100%.
yes,
So notice wrongly mentioned as 82.35%,
yes.
which has to be taken into consideration in the first instance. All these you have said,
Well,
but that is after a final so-called
and,
notice.
and moreover, my lord, there, my lord, there's some mistake, my lord, in the, their portal that I shall show from 257.
Have you found anything DVDMS portal?
Yes,
Mr.
my lord.
Bora?
Yes, my lord.
If your losses.
No. In the
No, in the, here I have not
that
found it.
will measure your percentage of supply from DVDMS portal.
DVDMS portal, my lord, where, my lord, the concerned recipients, they can enter the data, the supplier, he can also enter the data, whether it has been supplied. And after delivery, the concerned district officials, my lord, they also put the data, whether it has been received or not.
Is there any mention somewhere in the tender document or bidding document or contract agreement? But that is what I have said, asked.
Yes, my lord. Here it is not mentioned, but it is a, my lord, web-based supply chain management system, my lord. Centrally,
My lord, one page your losses may see.
where the supplier can also put the data and the recipients.
257, my lord. This particular medicine, my lord, dimethyl nasal drop, order is 27,200. Your lordship got it, my lord? And the portal shows, my lord, if you'll also see at page 260.
My lord, in 257, your lordship will find that clause, my lord.
Where is that?
In 257, my lord, under the table, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line, my lord. The supplier must upload the destination-wise challan detail in the official website, dbdms. This one, my lord. So supplier also can upload the data after making the supply. And
Supply.
yes. And then, my lord, the recipient of the concerned district, after receipt, they also put the data, whether it has been delivered or not.
Supplier
Sometimes-
must upload the destination-wide challan details in the official website.
By using,
Of DVDMS by using provided user ID and password before commencement of supply.
yes, my lord. So that sometimes issue arises that they put the data that they have supplied, but it is not delivered there, my lord. So if it is delivered, then in the that system, it is shown delivered, my lord.
Items are delivery login and so it is you who has to put the data.
Yes, my
My
lord.
lord,
It is you.
Yes, my lord.
And that is what the document is. Come to final document again, final notice.
Yes, my lord.
Let us have the final, revisit the final notice. Every purchase order contains that clause.
Yes, my lord.
Contains that clause. Where is the final notice?
my lord, the final notice is
Ah.
at page 131.
1511 1511.
131.
Page 131.
131. 411.
Now, see 132.
Yes.
Third paragraph. Details of delivery status as on date as per the DVC portal is enclosed at Annexure A with this letter for your reference.
Yes.
Now come to Annexure A. Page 134.
Yes.
So it is your entry. That is what every purchase document contains the clause. You have to upload the destination-wide challan details in the official website. So that is your datas.
My lord, they are,
Then thereafter, nothing to be looked into by the court.
no, my lord. Actually, my lord, this is always maintained by them, my lord.
No, it is whether with
although it
your user ID and password, that is exclusive to the supplier.
Yes, my lord.
I don't think.
Then don't think, we'll close this. It is part of the supply order. If you say, have you raised any complaint that, yes, I do not have user ID, password to put the destination wise supply details.
I'm checking it.
In fact, in
No.
one of the matter on earlier occasion also, I got it, my lord. They put the data that it has been supplied, but it has not been delivered. Then I confirmed this process.
Even
my lord.
if,
Yes, my lord.
even if it is not delivered,
Yes, my lord.
they have uploaded the data. Yes, we have started
Yes, my lord. That is
from
true.
destination to destination.
Yes,
It
my
will be uploaded
uploaded.
by using their ID.
Yes, my
And
lord.
that is their document
Yes, my lord.
page. This thing they have said
Yes, my lord.
in the final, the details of delivery status as on date as per DVD MS portal is enclosed at Annexure 8 to this letter for your reference. After giving the details,
Yes, my lord.
this is the position. Similarly, last one is which date? Final notice.
Final notice. 411.
And where is that? 13 item, 14 item, something, yes. There, page.
411,
Page
131.
136.
Yes, my lord.
136, they have said about many orders. Now 138. Enclosure. Annexure A.
Yes, my
Annexure A, page 139.
Yes, my lord.
And definitely it appears to be.
My lord,
yes,
it is uploaded, my lord, that two part, my lord. So far we have supplied, that is, we have given there, and so far they have received this, so, my lord, from the there, that is separately.
Hmm.
And now they have given it as per their references. That is why cumulative have taken the stock. So here, my lord, now, finally, my lord, we have supplied more than 90%. That supplementary affidavit, my lord, shows that we have supplied. Farm rate is there, that is why, my lord, only and they have home delivery as per MSCL is less, my lord, but we have supplied more. 849, your losses may see. How currently, funds is 847. Delivery as per MSL, company medicine
Which one?
delivered as per so.
Which one? Which page?
Page 849.
Huh?
849, supplementary affidavit. All the proof we have given also, along with the petition. All the three challenge are there, madam.
849.
849. Serial number 6, my lord. Percentage of delivery as per MSCL. MSCL. It is shown as
849.
yes.
Which one? Which one you are reading?
849 item number, my lord, serial number, my lord, no, right in column, 6th column. 6th column. Percentage of delivery as per MSCL. You also got it?
No, where from it is generated?
We have done it, my lord.
Any from the portal?
No, they have compiled it, my lord.
Well, all the challenges are there, well, all the challenges we have annexed here. Separate purchase orders are there, and we Yes.
Is there like that they have said
Yeah.
that this is from the DVD MS portal?
Yes.
Is there anything that you have said?
Well, that is with them, my lord. We have also uploaded our
Must
supply.
upload the destination.
We have uploaded, that is kept separately.
Website
And they,
by using so and so. The item service supply logo barcoding restriction.
and
Is
Hi-
there any mechanism, Mr. Bora?
And highlighted ones are, my lord, it highlighted supply orders are mentioned in the department notice. My lord, here you also will find some of the orders are 100% supply, 0% they have shown. 100% supply.
No, then it will be go to into disputed question of fact.
Yes.
Yeah, it
But I-
seems like that.
Which is
No, I'm
not
not,
the territory.
no, I'm not on that, my lord.
It seems
I'm,
like that, my
I'm-
lord.
So,
I
I
said-
am just asking that since you have the authority with the upload the details
Yes.
in the DVD MS portal
yes,
by using your passcode and bar or user ID,
yes,
whether after this say supply must upload,
yes.
whether there is any mechanism for you to verify and
Yes, my lord. In fact, my lord,
is there
after,
anything? Is there anything in the record like you after repeated query you have pointed to this?
yes, my lord.
Right.
Yes, my lord.
Now again I have to make a repeated query to you, then you will find out from this document
No, my lord.
not readily.
In our affidavit, my lord, in fact, after the debarment notice, they file one representation that your lordship has pointed out in the writ petition. So in our affidavit also, we have taken care of that day after they are after filing the representation dated 24/11/2025, we inquired to all the district offices, my lord, whether the materials have been supplied or not. So that I have stated in my affidavit.
So this is your ground that you have supplied all the materials,
Yes.
More than 90%.
90%.
Right.
So there is no cause of action for
Yes.
debarment.
Secondly, my lord, I shall come to that shock cause also, which is, my lord, 2021 1 SCC 804. Para 8, 807. What is just it para 8?
Just will go to that.
Yes. There is no dispute.
1 minute, 1 minute.
Well, hold on. Eh, what- no- no dis- Any- no, no.
Yes, which paragraph?
Para 8, my lord. There is no dispute that the injection was not supplied to the respondents by the appellant. Yet so-called notice dated so-and-so referred to further action in terms of tender for supplying misbranded medicine to the appellant. Furthermore, so-called notice did not state that the action taken by blacklisting or to be taken or was under contemplation. It only mentioned appropriate action in accordance to the rules of the tender. The fact that terms of tender have provided for blacklisting is irrelevant in the facts of the case. The absence of any supply by the appellant order blacklisting so-and-so tender is a fundamental flaw, restating the impugned order on the face of it, reflecting non-application of mind to the issues involved. Even after the appellant brought to this fact the attention of the respondents, they refused to pay any heed to it. Further, it specifies no duration for the same. So, my lord, they cannot say only, my lord, that as per tender clauses, my lord, action will be taken.
And it is, come to again, find first so-called notice, second so-called notice, we
Yes.
don't know.
Yes, I shall.
Yes, Mr. Bora, you place it before the court.
Yes.
Final so-called notice,
Yes, my lord.
final so-called notice,
So-called notice, my lord, your losses may come to
page
page
118,
101.
118.
Yes.
No, 101 is also there, my lord.
That is 117. You have not placed us the first so-called notice, second so-called notice, right? We are into now 117. Okay. Let us go to final so-called.
Yes.
101.
Yes.
Right. 102. Hence, in the
Therefore,
greater public interest,
No.
you are asked to show cause why your products should not be debarred as per the referred penal clause in the tender. Clause number 5.
yes.
For failure in execution of supply, non-supply, default in supply.
Yes.
Is it going in conformity with paragraph 8?
So that is, my lord.
Let us see what is paragraph 8.
Finally, last, my lord, page 102. Last.
So coach,
So-called reply is noted that non-supply of.
what more is required? Clause 5 is in bold.
My lord,
Everything is quoted. What more is required?
quoted
Sir?
is different, my lord. Quote may
That
be.
you are asked to show cause why your product should not be debarred.
Yes, product should not be debarred.
Yes.
Not farm. Not farm.
Then
Final.
118.
Yes. 118.
Bold.
My lord.
Bold.
Yes, 118.
Please be noted that if 3 of your empanel product will be debarred for which your company failed to execute the desired supply, it will result in the debarment of your company
Yes.
for a period of 3 years.
Yes.
It is given in bold.
All, my lord, 3 of your empanel product will be debarred.
Yes, both together.
Yes. So, 3 products have to be debarred first. First 3 products have to
That is not
No.
the intention. It can happen if 3 products, it will automatically entail
Yes.
debarment of the farm. That is the understanding of the
Yes.
clause 5H.
So, first product is to be debarred first. Well, 2
This can happen simultaneously also.
simultaneously also, but first thing, my lord.
If 3 products,
Yes.
if less than 3 products,
Yes.
it is product debarment. If it is 3 or more,
Yes.
then product department, not only product department, the farm department.
Correct.
Yes.
That is what I.
That is my understanding.
No, that is I
No
submit.
separate order, this, that, not required. I don't think that submission. But so far as paragraph 8 is concerned,
My lord, first.
this paragraph.
There is no farm demand. There is no cancellation of the that contract. Now, if you also see the judgment, my lord, I'm giving it. Huh? Yeah. This judgment, my lord.
On this paragraph 8,
Paragraph 39 onwards, my lord. Paragraph 39 onwards. Same, my lord. Here.
Which paragraph?
Paragraph 39. Forty-two and 40.
This has to be read in full, otherwise it will be difficult.
No, 42 and 43. if you
No,
also-
to understand what
Yes.
the court has meant.
My lord, because that clause is.
Because I said I understand slowly. If this is the same kind of contract,
Same contract,
then this has to be followed.
my lord.
If
Same
it
contract.
is really the facts and circumstances
Same,
in this case
Same.
is same, then this whatever rightly or wrongly it has been passed, it has to be respected.
My lord, because that has been quoted here. also.
Right.
Yes,
And if Mr. Bora, if it is same facts and circumstances, then this is to be followed.
yes,
Well,
my lord. But
Page 8, my lord, that has been quoted. Again, same.
only difference is that, my lord, supply of items.
I
Because
can
that is-
supply,
that
medicine
is
name is,
disputed.
if the
No,
principle.
quantity. It is, in this case, it is less than 90%, my lord.
There also,
Yes.
There, my lord,
Rate contract.
this
Yes,
has
sir.
to be understood. Court has said there should be product department, thereafter it should be followed by farm department. Right. As if the supply, hands are tied for the purchaser,
yes, my,
it looks like. So if that is there, then this is to be followed,
yes, my,
whether it is
yes,
rightly decided or wrongly decided, that is a different matter, but it has to be respected.
yes,
The facts and circumstances of the case. If it is holding the field, then this is to be followed.
yes, my,
But I have not read it fully.
yes,
But Mr. Sayola, if that is correct, that facts and circumstances of this case is same as like the case
Yes.
decided.
that issue is same, that first product department and then farm department.
Ah.
First, cancellation of rate contract.
Ah.
What that judgment
yes.
says, my lord. First, cancellation of rate contract, then 3 product department, then farm department. That much that judgment says, my.
So if that is there already, if that is not say reversed,
Yes, my lord.
then that has to be followed.
Yes, my lord.
But I have to read it.
Yes.
Without reading it, I cannot
Well,
say fully or subject to your that this is applicable.
Yes, my
Then we
lord.
can go by it.
Yes, my lord, that is true, my lord. It is in respect of similar kind of work and same agreement, framework agreement.
Okay. If it is same, then we'll read it, then dispose it of day after tomorrow. I'll
Yes,
read
my lord.
it so that
Yes, my lord.
if this is applicable,
Yes,
it's applicable. So far, this is concerned, this is
but only difference is that, my lord, in paragraph 46, my
should
lord,
not be debarred.
paragraph
Right.
40.
1 minute. Where is the debarment order?
my lord, yes. Lord, Department order is at page 130, 136. Page 137.
Now, Mr. Bora,
Yes, my lord.
find out what is the 17 number of drugs, essential drugs,
Yes, my
and what are the 13 number of essential drugs, total non-supply.
Yes.
Then 137. Page 137.
Yes, my lord.
You have to show us third para.
Yes, my lord.
Upon non-completion of desired supplies, third line,
Yes, my lord.
product stroke farm department will proceed. But as per the DVDMS portal details as on date, a total non-supply of 13 number of essential drugs,
Yes.
right?
Yes, my lord.
Against 17 number of POs. So POs may contain many drugs, essential drugs.
Yes, my lord.
Now there the allegation is 13 in case total non-supply. Right or wrong, you have to say whether correct or not. I am not going to calculate it. Then, where 11 POs were found below 80% supply, 6 POs are found above 80%, but below 90%, and for 1 PO, supply has not been started. Now, next. Therefore, in the greater public and patient interest, your company is hereby blacklisted and debarred, that is, farm department,
Yes, my lord.
from participating in any tender for 3 years,
Yes.
right?
Yes.
From the date of issuing this letter, as per referred tender clause number 5. 5, then subclause H, down below.
Yes.
Point number 2, that is farm department. Point number 3, forfeiture, and subclause M for default, right?
Yes, my lord.
Default, that is there, already quoted. Then, in supply of 13 number of essential drugs against 17 number of POs. So, whether 13 number of essential drugs total non-supply, is it a correct statement? If not correct statement, wrong. Have you understood?
Yes, my lord.
Where is the total non-supply? Does not look like page 139.
Certainly.
Yes.
Some drugs are, my lord, same drugs, different purchase order. Just like 6 and 8, same.
My lord, that aspect we have in our affidavit, we have stated, my lord. In our affidavit, after their representation, my lord, again we communicated with the district offices, my lord. Page 902, my lord.
Which additional affidavit,
No.
petition or petitioner?
Affidavit, page 902, your lordship. 902. Affidavit in opposition by the respondent number 4, my
Ah.
lord. 902, my lord. Clause number 2 is the representation filed by them, my lord. Then clause number 3, to verify the petitioner's claim regarding pre-debarment dispatch and alleged strike-related non-delivery of consignments, confirmation emails were collected from concerned district drug store managers and medical college hospital pharmacies across all identified locations. Based on the confirmation emails received from district level authorities, the following consolidated verification table has been prepared. So it is in respect of those 13 numbers, my lord. But out of 13 numbers, my lord, 2 at serial number 2 and serial number 11, that has been verified that it has been delivered, my lord. And at serial number 13, it has been delivered after preparation of the debarment notice, my lord. And this purchase order, my lord, purchase order tallies with the purchase order at page 139 also, my lord.
But you have drafted the bidding document in such a manner, this clause F is rate contract,
Yes,
not the purchase order wise.
yes, my lord. But my lord, these
You
are,
have
yes,
prepared in that manner only.
yes, my lord.
And that is what it has been interpreted by the coordinate bench.
Yes, my lord.
Then
That aspect is there, my lord, but another aspect in that judgment, para 46 and 47, there, my lord, it was a conclusion that, my lord, in that case, the petitioner has supplied more than 90%, my lord. Para 46. So accordingly, the decision was,
ultimately, we have to go by the debarment order
yes, my lord.
and
No, regarding the debarment, that will be there, my lord, but otherwise, because in that case, my lord, the honorable court has been pleased to held that, my lord, the question of cancellation of the rate contract or product debarment in terms of
which
clause,
paragraph you are reading?
paragraph 46, last portion is that paragraph 46, my lord, that it has petitioner number 1 has completed more than 90% supply. Then conclusion is 47, my lord. Ultimately, my lord, debarment notice has been set aside based on this conclusion also. Because it says that they have supplied more than 90%. So debarment doesn't arise. At best, there could be penalty, my lord.
We don't know, we cannot calculate how much, what are the essential drugs, 17 item, it is very difficult for
It
me.
is a disputed.
It is
Now,
A, B, C, D,
Yes.
yes, I can. This penicillin 500 grams.
Yes, my lord, it is
0.00,
very
it is difficult for me to
difficult,
read.
difficult, complicated.
List the item, list the 17 item, essential drugs, which you have referred to, and how much they have.
No, that 17, that page 139. That 17 drugs, my lord. Page 139 of the debarment notice, my lord. Which says one item has not started supply at serial number 16, my lord. Paragraph 3 of page 137 is in reference to this table, my lord, page 139.
But that judgment says, as a whole, the item wise, total cumulative. Is it not?
Yes, my lord, that is true, my lord, but on the
But
basis
it is
of,
not purchase order wise.
yes, my lord,
A particular, say, penicillin,
yes, my,
it may be covered by many purchase order,
yes, my lord.
right? If I have understood it correctly,
Yes,
rate contract is for penicillin, say rupees 10 rupees.
yes, my lord. Yes, my,
That is rate contract
yes, my
for
lord.
penicillin.
Yes, my lord.
And this penicillin was ordered for
Whenever,
delivery at many destination.
yes, my lord.
So as a whole cumulative, penicillin was supplied within delivery period less than 90% or more than 90%. I think that is the purport of this, perhaps,
Yes, my,
judgment.
yes, my,
That is not there, neither purchase order wise. If I have just had a glance,
yes, my lord.
I have not understood. But so far, it indicates that rate contract means rate contract for one item, essential drug. And if you go by clause 5H1, then it is that essential drug only, not purchase order.
Yes,
That is why in paragraph 46 and 46, he mentioned about 4 drugs.
product development.
That is perhaps,
Yes, my lord.
even if I say, because if how it is relevant, I don't know, that if he failed to do three essential drug delivery, why cannot go together? I have not understood, but still,
Yes.
still, if three is over, then why not the whole farm itself?
Farm development.
But I have not understood that it should be preceded by on so and so.
Product.
But so far as combined, what he has said that a rate contract is for one, say, penicillin, then it has to be specific to penicillin,
Yes.
not purchase order wise, because say 139, this carbo so and so drop, first one.
Yes, my lord, I understand.
This is covered in many purchase order perhaps.
Yes, my lord. Then
So
item 6 and 8 also, dopamine.
Dopamine say injection. This has been ordered to many destinations
Yes, my lord.
by various purchase order.
Yes, my lord.
So overall supply of it, you have done it in such a manner, the clause, rate contract, perhaps you have dug your own grave.
Yes.
If the judgment I have understood, just having a glance.
Yes.
So you have traced in such a manner, had it been purchase order, you have made it drug wise.
Yes.
Had it been purchase order wise, then 139 is clear. They are beyond 90 days, 75 days, gone. Right.
Yes, my lord.
But you have structured 5H1 in such a manner. Okay, let me have a reading of this. judgment.
Only thing, my lord, I shall show even after verification, how that is perverse. Your lordship, page 903, they have given a chart, my lord, in their reply.
Page
903, they have given a chart.
90.
903.
903.
The table that I have referred to.
That is again a different.
I'm just showing, my lord, that Hailakandi, that is at page 190, if you'll still see, Talan is there and bill is there. We have prepared the tax invoice. Same thing.
That is the dispute. That's why on their data it is showing it.
Destination wise, you have given destination right here.
Yes, we have supplied.
Here in the debarment order, you have given purchase order wise.
Yes.
And
But in one part,
and in the tender clause, in the contract clause,
yes,
that is product wise, essential drug wise.
yes.
So all three are different.
But in one purchase order, there may be 2-3 destinations also.
Yes.
Product wise, that is product wise. That is product wise. Like my lord,
Let us see.
my lord, if for instance, if page 139, if your lordship takes serial number 2, that
One.
serial number 2, page 139, octreotide injection, that purchase order
139, serial number 3.
2,
2.
for instance, my lord, this purchase order and this is meant for supply to Nalbari and my lord, Nalbari and Shunitpur.
Come to that, say 257.
Yes.
Let us see the purchase orders. Sorry. Destinations are many.
Yes, destinations are many.
Destinations are many.
Yes.
Destinations are many.
Yes, my lord. In one purchase order for one.
Whatever be the destination,
Yes.
drug is one.
Yes.
Then delivery schedule is to be maintained.
Yes.
Say 150, 258, Mr. Sayola.
Hello?
258.
258, yes. 258.
Xylometazoline.
Yes.
Nasal drop.
Yes.
Right? Nasal drop.
Yes.
This nasal drop, purchase order,
1.
it is
fixed.
Yes.
Parcel order date is fixed, 28 to 2025.
9 destinations are there.
9 destinations are there. Whatever be the destination, everything is to be delivered within 75 days.
75.
No matter what.
And
So
to-
then if 139 is to be read in that context,
Yes.
Yes.
139.
So total quantity is also there in the purchase order.
Now, is the nasal drop there?
Yes, my lord, it is
Which serial number?
139.
Xylo, yes. Xylo, that is
Serial
there.
number 12.
Item
my
number
lord.
12.
12, my lord.
Item number 12.
Yes.
Two 257, 258. So there it records 82.35%. 82.35%.
Yes.
Quantity. 27,200.
Yes.
So one purchase order for one essential drug,
Yes.
is it not?
No, no. In one purchase order, several drugs are also there.
Let us see, let us see.
Yeah. Yes.
Because nobody has addressed me on that point, you have
No.
taken.
If your lordship will see our.
Which one? Let us
Yes.
see your purchase orders.
Yes.
Let us see.
The table is there, my lord, we can.
No,
show.
I'll see the purchase orders. No
yes.
table.
My lord, I can show.
Come to 198.
Yes.
Yes, 198, one drug.
Yes.
205, one drug. One
These are-
drug.
They are mentioned in the department. that-
One drug. 210, one drug.
Yes.
Then 214, one drug.
Destination may be many.
Huh?
There may be many destinations, but the
Destination different,
Yes.
because I've been made to go round and round. Everywhere it is single drug purchase order.
My lord, these are mentioned in the blacklisting order. That is why you have next. Otherwise, my lord, there are orders. Table is there, my lord. That is why I want to show
But
the.
I want to see the main document, not table.
Yes.
I don't
Well,
see table.
Anyway, my lord.
This purchase order indicate one essential.
Yes, maybe.
Show me anything you have given voluminous brief. There are too many. Find out from one. Because unless facts are clear,
Yeah.
because every judgment is based on its own facts.
yes.
Unless facts are clear, Mr. Dasgupta, I don't think you should sit till this time. Maybe we are in a, what do you say, vortex of facts. Facts are not even clear. I've been made to do Magellan. Round and round and round. Zule Bharni or what? Around the world in 80 days.
Item number 10.
When do you want? A. Dasgupta, Senior Counsel. You are for the petitioner? Petitioner? For the petitioner?
He is for the petition, I am for the respondent.
Okay. S. Chakraborty, respondent. Sai Huli Lok, Chakraborty, Dasgupta. Yeah. Lage. Huh? Yes, any purchase order.
Hello? No, those, well, only we have purchase orders apart in the blacklisting order. These are.
Show me any by purchase order, two
We have.
more than one essential drug was ordered.
If necessary, we can submit additional affidavit. Everything is there.
No, you can indicate because all these are here, I think.
No, that chart I have given, madam. Chart I
Because
have-
purchase orders are here.
Yes,
You have annexed,
yes.
right?
I have.
And the purchase orders are here. Then I have to read the judgment. If it goes exactly, then we'll respect this.
Yes, my lord.
And it is not, facts are not similar.
Yes.
Then we may have to
Yes, my lord.
pass separate judgment.
Yes.
That is all.
And my lord,
Indicate,
my lord, I can,
indicate to me that the purchase orders are only in essential drug wise, one essential drug. As you have shown, if that is the correct position, say 257, we have gone there.
in respect of one item, my lord, 7 purchase orders are there.
That is what I want to,
No,
I
that-
want to, no,
That is chart is given, my lord. That only. If you also see, my lord, even in their page 903,
just 1 minute, 139, come to 139.
139. No, nothing.
Other than these 17 purchase orders,
Yes,
right?
yes.
Any other purchase order?
Yes, my lord, in 139, if you also see, dopamine is there in 2, 6 and 8. 2 purchase orders are there.
Huh?
6 and 8, same medicine, 2 purchase orders. Similarly, 5 and 17. 5 and 17, same. 5 and 17, same. Different purchase orders, sir.
Okay.
My lord.
For how many products or essential drugs you have been empaneled?
Page 68. Page 68. Many items.
60. Many you will not do.
Yes. 68.
I'm
giving
giving
the-
specific.
67 items. 67.
For 60?
7.
This is generalized.
Yes.
And in respect of how many essential drugs you have got purchase order?
Hello, I'm telling you. Wait.
Can you
It's a-
give it in a
No, it is there, my lord. It is there. At page 849.
Huh?
At page 849, it's there.
No.
9.
This is not
9.
849, not
No,
9.
849.
No. See 10 to 16, dopamine, same. So
no.
tell me, no.
So we have total 9 drugs. The purchase orders are there, but the total 9 drugs.
Please give me a piece of paper.
Yes.
Mr. Sahiwala, just give me a piece of paper.
We shall give it to
Huh. Give me that, say dopamine.
Yes.
Then say nitroglycerin injection. These 9, right?
Yes.
Then if that is so, by this 249, different purchase orders are there, and 90% has to be calculated on the basis of each essential drug.
Yes.
To cancel the rate contract.
Yes.
In respect of the each purchase order that will be made.
5H, I have said.
Yes, my lord, because why I am saying there may be different purchase order of different dates, my lord.
Let us see 5H1.
Yes. Yes, my
And that has to be looked into with the
Because, my lord,
interpretation given by the
suppose
coordinate banks.
dopamine, there may be a purchase order of February month, then subsequently.
I'm
when-
afraid that interpretation.
Yes, my lord.
Now already there is
Because
an
the-
interpretation, Mr. Bora.
Yes, I understand.
Even if I want to go in that way, I should not go.
8 total
Right.
order.
Because purchase order.
Where is the 5H clause in the main?
Page 47.
Page 47, my
Page
lord. Because 75 days has to be counted in respect of each purchase order from the date of approval date of the purchase
Let
order,
us
my lord.
see
Yes, my lord. That is less than 90% of the total
Total order quantity.
ordered
Wait.
quantity. Ordered quantity means, my lord, whatever.
Which, supply. No, 5H1 is concerned rate contract. Rate contract, concerned rate contract.
Yes.
Some rate has for
Yes, my lord.
penicillin say or dopamine,
Yes,
a rate is arrived at say rupees 10
yes,
per
it is quoted by the,
quoted
yes,
or L1 rate,
yes,
something like that.
yes, my lord.
Rate contract shall be cancelled.
Yes.
That rate contract for dopamine.
Yes,
And the manufacturer or firm shall be debarred from participating in any bid called by the authority for 5 years from the date of debarment for that item. So
Yes.
dopamine only,
dopamine.
right?
Yes,
So this non-delivery
yes,
within 75 days
yes,
from the purchase order
yes,
is to be calculated for dopamine,
dopamine. But
whatever, from
for-
both.
for dopamine, there may be more than one purchase order also.
Right, but that interpretation,
Suppose, because
that you have not raised that argument perhaps, and you have not gone for
probably
review or
at that moment, in that
review or
case,
read appeal.
yes,
Is it
no, my
appeal?
lord.
No.
No.
Then
Because suppose one order has been placed in the month of February, then subsequently
I
another in July.
understood.
Yes, my lord.
I could have understood it.
Yes,
But
my lord.
now there is a limitation to such understanding.
Yes, my lord, I understand because I am also taking time to understand this complicated matter, my lord. Because,
Right. So one could have gone
yes,
in that manner also.
yes, my lord.
But that understanding is now limited
Yes,
by the interpretation already given,
yes, my lord.
right?
Yes,
So we have to respect that.
yes, my lord.
So
Understood.
that is why I need to read that
Yes, my
order
lord.
to understand
Your lordship may
this
examine.
petitioner's case and that petitioner
Yes,
case.
your lordship may
And this
examine.
petitioner case, if similar,
Yes,
then we have to go by the similar order,
yes, my lord.
right?
But that aspect is there, my
Sitting
lord.
in court, I cannot read the entire thing.
Yes, my
It
lord.
it runs into 32 pages.
Yes, my
So day after tomorrow,
yes, my lord.
if you can find out anything, that is okay. Otherwise, if
Yes.
this goes, there nothing to be deliberated upon.
Yes,
And if does not go similarly, then we may hear you further.
yes, my lord.
Right?
Yes, my lord.
Lord,
That is the understanding. If your case is similar to this, nothing is required to be heard.
No.
But if I think that on such point you have to address, then I'll point out, you'll address.
But
Yes.
Otherwise, no point wasting time.
day after tomorrow, I shall not be here, madam. But my friend will be.
He'll be there. If some point I need, then I'll give you some
Well,
time. Right?
well.
But if it is covered, then no point
No point.
Yes.
hearing.
Yes.
Right?
Yes,
Otherwise, if you have said that, please read this, whether my case is similar, then I could have read this and
Yes, yes.
no point hearing it. If it is a covered case, covered case.
no, my
When
lord.
there is no appeal or
Yes,
review.
Well,
yes,
So I think you are the counsel.
yes.
So there is no review, no
No,
appeal.
not yet.
So it appears to have attained finality. Okay, then day after tomorrow you'll be there. We'll find out.
Well.
It is covered case, we'll pass the order. Ian Savala, Senior Counsel, State by Mr. M. Sahal. Petitioner, P.P. Bora, Standing Counsel. Health and Family Welfare Division. All the response. List the case again on Thursday for consideration.
for consideration. এইটো ফাইলত থাকক এটা উলি বাকি হিন্দু বুজি পাইছো ফাইলত take further matter. Yes.
6, take a date if possible. 17th.
6. What is the matter about?
It's regarding dispute regarding electricity dispute, theft and unauthorized use.
Okay, you are having a stay.
No, there is no stay.
Okay, 17 to DD was added.
17.
Mr. F4ED, a request of F4ED with the consent of the landed council for the respondents, if you inform.
Yes.
This is the case 2017, all home color DD, but overlapping of an free date of DD, free date of. Let it be on the upper side, higher side.
Yes, Lord. Much obliged.